of scholars, but also a global initiative to reflect, critique, and engage with the evolving dynamics of standard essential patents, patent licensing, global technological development, and competition law. We look forward to rich discussion, collaborative insights, and the shaping of ideas that will define the future of intellectual property and innovation. Thank you and welcome once again. Now, I would like to invite the first participant of this conference, Ninad, sorry, Ravi Pandey, a student from Shado University, to present.
Madam, my schedule is from 10:16 a.m.
Actually, the
Yeah,
first
Mr.
participant of the
Ravi
conference is
Pandey.
not available right now.
Yes, Ravi Pandey, you can present your presentation. Like we will initiate with you.
Okay, just a moment, sir.
And all the participants kindly note, kindly stick to the schedule of the session. And the schedule is per participants are only allowed 6 minutes for the presentation. So 5 minutes you can present, and 1 minute is for Q&A for the if there is any questions from the panel would be asking you. Yes, Mr. Ravi Pandey.
Sir, I'm preparing the system, so it may take another 2 minutes.
After Ravi Pandey, we are having Nitya Singh and Paritosh Singh. So kindly
Sir,
be prepared.
we having Abhishek Chaurasya.
Okay,
She's a
yes,
student from
also
Indore
Abhishek
Institute of
sir.
Law, Abhishek Chaurasya.
All right. So we'll be initiating after Ravi Pandey these two participants. Mr. Ravi, kindly be fast.
Sir, my my PPT is not opening. Can I continue with the paper that I have submitted? I mean, the same reflection, the same images I have
Okay,
used.
you can present without your PPT. You just turn on your camera and start your presentation.
Okay, sir. Okay, thank you, sir.
Please be fast, Mr. Ravi.
Actually, sir, I'm trying to open this StreamYard from my system. That is the main reason why it is taking time.
Ravi, your screen is not visible yet.
Madam, I'm trying my level best. Can I get another 10 minutes to manage this issue? Meanwhile, if you could please call for the next participant, I'll be ready in
Yes,
next 10 minutes.
yes. After one,
You're
two
also
participants
breathing
will
a
be
lot.
calling you. Yeah. Okay, we can go with the
Sir,
Abhishek
can we proceed to the
Chaurasia.
next participant?
Yes, we can move with the
Okay, sir.
Abhishek. Yes. Where is Mr. Abhishek?
To invite now AR Vara.
Ma'am, may I
From
start?
yes, Nitya Singh, you may start. But you are not visible, Miss Nitya. Kindly turn on your camera.
Sir, actually, I'm
Yeah.
sharing my PPT.
Your PPT is also not visible.
Uh, your voice is glitching a lot. Can you fix that?
Ma'am, actually, there is a glitch. The PPT is not showing in
Miss
this.
Nitya, start presentation without your PPT. We'll be proceeding with that. Just start.
Can you
Just turn on your camera and proceed with the
again?
presentation.
Is it visible?
Yeah, your PPT is visible now. Yeah, you may start. Your screen is visible, but you have not opened your PPT yet.
Is it visible, sir? Now?
It's only screen what that is visible.
Actually, there is a glitch, sir.
You have to give permission to the complete desktop for your presentation.
You can straightforward. You can start your presentation.
Okay, okay. Good morning, everyone. My name is Nitya Singh, and I'm really happy to be here today. The title of my paper is From Collaboration to Control: The Legal and Economic Dynamics of Patent Pools in Emerging Tech Markets. In this presentation, I'll be explaining what patent pools are and how they help or harm innovation, and why it's important to make them fair for developing countries like India. uh, Patent pools are groups where companies come together to share and license their patents in one piece. Instead of companies paying for many patents separately, they can take a license from the pool. Then This is what we helps that it reduces legal fights and makes it easier to use a new technology. So basically, patent pools are very useful in fields like 5G, artificial intelligence, and the Internet of Things, where many patents are used in one product. But now we are seeing a problem. Instead of helping everyone, patent pools are mostly helping big companies. Smaller companies, especially from countries like India, often don't get a fair chance. So, in this research, I looked at three questions. The very first is: do patent pools still support fair innovation, or are they now being used to control the market? Second, how do different countries like the United States, European Union, and India regulate these pools? Third question is: what changes can we suggest to make the system better? To answer this, I have studied legal rules, compared laws from different countries, and reviewed government policies and reports. Therefore, many patent pools include something called standard essential patents or SEPs. These are patents that are needed to follow a technical standard. For example, to make a phone work with a 5G network, you need to use some SEPs. Now, when a patent is essential like this, the owner must give license to other under something called FRAND terms. FRAND means fair, reasonable, and non-discriminatory. These rules are made to keep things fair for all companies, but in many cases, these rules are not followed properly. Big companies still demand high fees or unfair conditions, and smaller players can't fight back. Let me give you three real examples of patent pools. The first is MPEGLA. The second one is Avanci, which means this one licenses patents used in 4G and 5G cars and other connected devices. And the third one is via licensing. It focuses on wireless and audio technologies, and they try to be more transparent about the process or some of the prices. Even though patent pools are helpful, they also have many problems. Like sometimes companies in the pool agree on high prices, or there's a problem called patent holdup, where the patent owner asks for very high fees after the patent becomes more part of the standard. And then we have a royalty stacking, when a company has to pay multiple fees for many patents just to make one product. There are some challenges for emerging economics, where I have mentioned in my research paper. Therefore, in developing countries like India, Bangladesh, or Kenya, there are entire problems like the licensing fees are too high. Small companies don't have legal teams to understand the contracts, and they are not included in pool decisions. That's why many small innovations just give up. In India, the Department for Promotion of Industry and Internal Trade, or DPIT, is trying to improve access. In Africa, the African Regional Intellectual Property Organization is doing the same, but the process is still now slow. Now, let's look at different countries handle patent pools. In the United States, the Department of Justice and the Federal Trade
Yes,
Commission give
Nitya,
guidelines.
what are your suggestions and solutions? Just move ahead with this and try to wrap up in 1 minute.
Yes, sir. The Sir, I have the suggestions. They make the rules and set high prices, so the small companies or people from developing countries don't get a chance to join or speak up. So instead of helping everyone share technology, the system ends up helping only a few, so they can't afford to make new products or grow their business.
Okay, that's your conclusion.
Yes, sir. To end the patent pools started with a good purpose to make just licensing easier, but now they need to do more than just follow rules. That's the change we need today. Thank you, sir.
Okay. One question for you I'm having specifically, you talked about the collaborations. Your topic talks about from collaboration to control.
Yes, sir.
So, like when we talks about the dynamic economics like India, which is growing like so rapidly than even the Western countries, because we are the intellectual hub of the world at present. So, for India, what are the challenges specifically patent pooling is facing right now?
Sir, in India, basically I have already mentioned the licensing fees are too high, or the small companies don't have legal teams to understand the contracts. And I have also mentioned that they are included in pool decisions. That's why small companies or innovators just give up. So in India, Department for Promotion of Industry and International Internal Trade is trying to improve access, but the process is now still slow or still in work.
All right. Okay. Thank you for your presentation.
Thank you, sir.
Now we will move with Ravi Pandey. Yes, Mr. Ravi
Shall I
Pandey.
shall I shall I start?
Yes, you can start.
Okay. Thank you, Team CDIPR. So the paper that I have submitted is Technology Transfer Strategies for Patents Across Offices in Academic Institutions across the USA, India, and Kenya. So I would like to clarify here that we have taken or we have considered three nations: USA, India, and Kenya. Uh, the reason behind the comparative would be explained at the later part of the presentation. Initially, our main objective was to understand what are the differentiating and what are the common strategies across offices in academic institutions across these three countries. What was the need to find a comparative or a differentiative common factor or differentiating factor was to find out what are the strategies that the technology transfer offices in these three offices are using. So the paper critically identifies the diverse strategies. So we have come across several research papers and also went through the patent office websites wherein critical details about the whether the patent has worked or not, these details were available from those patent offices, and that's how uh, they also became conglomerated part of the research paper that we have brought here. In addition to the patent office websites, we also went through several existing research papers that were talking about the percentage of the total annual expenditure. For example, India and Kenya, these numbers were not available, but for USA, 0.3% was the number which was available as per the government data, that they were utilizing this amount of fund for the promotion of technology transfer in academic institutions. So 0.3% of the overall budget is generally taken up by the technology transfer office across universities in USA to promote technology transfer. However, only 13% of the universities generated a revenue of more than 1 crore rupees through technology transfer. So, private organization and public funded organization again remain a differentiating factor within the country if we talk about the Indian perspective as well. So, these were the factors that we have summarized throughout our research paper. Uh, and that's how we have prepared this research paper. So I would like to bring years of experience. The differentiating factor in India and Kenya versus USA was the experience and the existing policy framework, the ecosystem that has already been created in the USA, and that was the same reason that was missing in India and Kenya academic TTOs across uh, academic institutions in India and Kenya, and that's how the pace at which the technology transfer is happening in USA was missing in Indian and Kenyan TTOs. 50% of the universities institutes had above 10 years of experience in IP. I'm talking about Indian perspective. If you talk about the licensing part or the policy framework part, Bayh-Dole Act has been in existence in USA for many decades. On the contrary, the national IPR policy came into existence only in 2016. The NISP, National Innovation and Startup Policy for India, came in 2019. So it is hardly a 10 years of experience for the Indian academic TTOs versus the TTOs in USA. 50% of the universities institutions had about 30 collaborations. Sorry. The
Mr. Ravi,
technology
what are
transfer
the
infrastructure.
Mr. Ravi, what are the challenges specifically you mentioned in your paper, and what are your solutions?
Okay, so I will come down directly to that. Sir, given the understanding of how the spectrum has evolved between the three countries, it can easily be seen that there is a difference in terms of the infrastructure, the policy, the experience, and the ecosystem between USA TTO ecosystem versus Indian and Kenyan academic TTO system. So what we have observed that developed countries versus developing countries is the main difference, wherein if you talk about the TTOs in USA, they have extensive manpower and funding, which is a functioning technology for technology transfer. And many technology universities and institutions, they already have a TTO operating for more than 4 decades, which is not the case in India as well as Kenya. If we particularly talk about this difference in Kenya, Kenya has taken few steps in terms of increasing awareness and development of promotion of technology transfer and filing of IPRs. There is one organization called as TISC, which has just a couple of years ago only has initiated this objective of promoting IPR filing and technology transfer activities, which is supported by the WIPO, and wherein some mandates have been given in order to promote the technology transfer ecosystem. So these steps have been taken, but again, the main uh, drawback or the missing part in these two countries is the lack of funding and the implementation of policy framework. Indian perspective has brought a couple of policy framework for the promotion of technology transfer and intellectual property rights, but the same is almost missing in the Kenyan perspective. So if we talk about the comparative or the conclusion from the three countries, USA academic TTOs are far ahead than India and Kenya. We talk about Indian perspective, we we have recently gained momentum in terms of filing IPRs and promoting technology transfers. IPRs are certainly the numbers and the volumes are good, but the technology transfer is happening in very niche institutions, that too in prominent IITs and ISC and ISERS organization, in addition to few couple of the private organization. Now, last, if we talk about the Kenya, the academic TTOs have not operated significantly in terms of doing licenses, in terms of doing valuation, transactions, in terms of having a proper policy framework.
Okay, Mr.
Although,
Ravi, come to your conclusion.
okay, so the key conclusion and recommendations for the current study are developed countries have an existing infrastructure uh, wherein extensive manpower, funding, as well as functioning system for technology transfer, is backed up by historic data and presence of policy, is certainly advantageous. The same thing needs to be imitated by developing countries like India and Kenya. Countries that are in the developing sector, such as India, have enough industrial as well as academic base and required to make efficient connection between the two. Academic and industrial collaboration is highly solicited. This is the major conclusion part that I would like to bring forward for both the countries, that is India as well as Kenya. At the end of the spectrum, many countries that are neither underdeveloped or in between a transition phase towards developing. The case of Kenya is seen as a rising uh, hope from African continent. Most of the efforts have come from energy and natural resources, intellectual promotion, intellectual property promotion, and translation and transition from ideation to a tangible product, that has been missing. Policy, funding, and trained manpower will certainly provide an advantage or certainly improve the current situation in India as well as in Kenya.
Okay. So, you had mentioned regarding the multiple technology transfer offices, TTOs, like across academic collaborations in Kenya. So, what is the major problem? Like in the multiple TTOs, what Kenya is facing right now is they are not having any consolidated unified system where like a filing of patent or in a consolidated database integration is done.
Yes, sir.
Specifically when like I worked upon some of the research projects on Kenyan intellectual property office. I we and like along with my team, we saw that the maximum duplication, that is the duplication in the filing of patents, are there in the Kenyan data sets when it talks about the multiple technology transfer office, because more the offices, more the number of applications and more the number of duplications. So how or what mechanisms according to you like can be provided to tackle up such duplication methods?
Okay. So in terms of duplication of uh, ideation, that can easily be tackled by doing a proper prior art search report for the inventions or for the disclosure or for the as filed documents. That is number one. For the inventions wherein the patents have been filed and the claims are written in such a way that the reproducibility factor is not there, though, so in that cases proofreading of patent documents can easily be done by the professionals, wherein it can easily be inferred out whether reproducibility factor is there or not in such patent application. It has certainly come across our literature review as well about the duplicacy part that you have mentioned in the Kenyan perspective. But industry does not easily gets convinced with the mere literature or the presence of claims or patent documents provided by the academic TTOs. Rather, they prefer to see high TRL inventions and presence of validated data backed up by the pool or the portfolio of patent applications. So mere filing of patents and mere having a portfolio of patent will shall not suffice the requirement to transfer the technology from the Kenyan perspective. If there are any databases which are creating a imitated version or the copied version of the content from somewhere, or the uh, unethical research practices are ongoing, so that will not eventually be reflected in the technology transfer transactions, because technology transfer or the transactions from the TTO requires validated data sets, tangible high TRL technologies. So that is certainly missing, and that is the reason why Kenya is far behind among all these three countries.
All right, Mr. Ravi.
Thank you, sir.
Yes, host, we can move with the next participant. You are not audible. You are muted.
Now I would like to invite Paritosh Singh Dev from Dr. Ram Manohar Lohia National Law University to present.
Hello, sir. Good morning. I'm actually traveling, so please forgive me if there are any issues with the network. Wait, let me start presenting my presentation. Just give me a second.
Okay, Mr. Paritosh, if you are facing network issue to even share your screen or share the presentation, you can present without your presentation.
No, no, sir, it's okay. Just I'll just take 1 minute and I'll just start presenting. Okay, can you see? Can you see this? Is,
So presentation,
Your screen
yeah,
is,
is not visible
is
it's
the
yet.
presentation
it's
visible?
visible. It's visible. It's visible. You can go ahead.
It, it is, right, sir?
Try to turn the pages like
Okay.
slides.
So,
Yeah, it's also visible. Slides are visible. You can start.
okay, okay. So I'm Paritosh from RML and NVO Lucknow, and well, let's get the basics on. So uh, I'll be dealing with FRAND commitments and royalty allocation and standard essential patent pools. And my main focus would be on the case studies on how various governments and judiciaries have been interpreting it and dealing with it in the present scenario. Now, it sounds like a mouthful, but trust me, it's gonna make sense. So now, first of all, let's think about it. Your phone connects to a Wi-Fi, your smartwatch is sync, and your car uses GPS, and it's all thanks to technical standards. Now, to use them, companies need standard essential patents, that is SEPs. Now, negotiating with each SEP holder individually would be a lot of chaos. So that's why we have patent pools where multiple SEPs holder license together. But here's the catch. They must do so on FRAND terms. Now, what is FRAND? Fair, reasonable, and non-discriminatory. Now, it's very hard to define what is fair and what is reasonable. Now, let's see. So legally, FRAND has two main identities. Uh, as defined as usually how US takes it, it's treated as a contractual promise. Now, as established in Microsoft versus Motorola, it is implemented and enforced like any other contract. But EU, it takes it in a different way. Now, in Huawei versus ZTE, it showed that refusal to license on FRAND terms can be abuse of dominance. Now, the trouble is that every country and every standard setting organization interprets FRAND differently. ETSI, for instance, requires FRAND licensing but never defines what FRAND is. So, what do we do? So let's look at this chart. So let's say royalties are collected but now comes the tricky part. Splitting the pie. Some pools do it by numbers, more patents, more money. Others by value-based allocation, rewarding patents that contribute more to the standard. But here's the problem. Not all patents are equal. And without transparency, no one can remember who wanted, and no one can remember what values more. So what do we do? Now, one of the biggest flaws is self-declaration. Now, SCP holders often declare their patents essential without scrutiny. Now, as I have shown in my study, uh, various studies have shown that 35% of declared SUVs are and others are usually slow. Now, corporation inflates royalty strips and hurts implementers.
Mr. Paratosh, you are having network issue. Your voice is scattering.
But unless
You are having network issue. Your voice is not audible.
hello,
Yes, you are audible now.
okay. So now let's look at some case studies to understand what I've been basically trying to say on how EU or the US or UK or various other countries, including India, deal with it. Now, MPEG LA, as one of the participants earlier mentioned these, MPEG LA, it helped video standards like H.264 spread globally, but it faced criticisms for lack of transparency in royalty sharing. Now, Avanci in the auto industry offered flat rate fees, as earlier mentioned, simple but tilted toward large SCP holders. Same go with Syswell. It introduced arbitration panels, but again, it's a very hit and miss kind of concept. Now, my main focus were on the case studies. Now, I would like to draw your attention toward this graph. It basically deals with the comparative approaches with various countries and various case laws. So let's start with UK. Now, in UK's Unwired Planet versus Huawei, the Supreme Court have said that FRAND could mean global licenses, not just a national. But in US, FTC versus Qualcomm, the Ninth Circuit took a hands-off approach and called Qualcomm hyper-competitive and not anti-competitive. Now, in India, Ericsson versus Intex courts leaned towards an affordability angle and added a component-based valuation. Now, let's see how governance works. So there's governance. Pools are often run by larger SEPs who set the rules, similar to players readily, smaller players readily getting a voice. So for smaller economies, so what can we do? Here are my personal suggestions, as I have highlighted on the slide. They will include, first of all, independent essentiality checks. It's very important. Secondly, statutory royalty guidelines. And a big example of this is SSPPU and other comparables. Now, third would be transparent SEP registers and disclosure of licensing data. Now, fourth is now clarity in interpretation and governance gaps. Now, unless we move towards transparency in independent verification and global convergence, FRAND risks becoming more buzzword than safeguard, as we have seen in FTC, Qualcomm, or Unwired Planet and Huawei, or Ericsson and Intel. All these cases can stand as pillars of these mishaps, which can be avoided if we just clear investors while keeping the access affordable and fair for all. Similarly,
Mr. Paritosh, your voice is not audible again. You are having a technical issue.
Hello, sir, can you
You
hear
are
me?
not audible, Mr. Paritosh.
Can you hear me?
Yeah, you are audible now. So, like, my one only question to you, specifically for your topic, like you had mentioned that there are a competition clash between the SCP when allocation with the licensing and reasonable licensing fees. So, how can the competition law framework in Indian context specifically can come up in such a way that it can distinguish the prices of going anti-competitive and also the competitive when we talk about the SCP licensing prices and the loyalty allocation models and distribution?
So, am I audible? Can you hear me? Hello, sir.
Yes.
So, okay. So that's a very good question. So, first of all, when we are talking about the Indian context, regulations particularly come into play. And the best example, as I have mentioned in my presentation and in my paper, would be Ericsson versus Intex. Now, in the question that you posed, the case itself actually dealt with it, funnily enough. And what they found or what they established was that courts, in particular, they lean towards affordability. Since India as a whole is a very developing economy, it's a much smaller field when we compare it to something like a country from EU or United States. So it's a much smaller player field. So our main goal towards that is affordability. So what Indian courts suggested was component-based valuation, and that was the major suggestion put in Ericsson versus Qualcomm, approach as shown in FTC versus Qualcomm, in which they basically dealt with hyper competition and anti competition towards royalty allocation and competitive based valuation. India, in this particular regard, is very US leaning, and that's how it plans to deal with these particular things. Syswell, Avanci, and MPEG-LE are also major components in that particular decision on how courts viewed it. And all in all, the bottom line of that would be that in governance, SCP holders, like larger SCP holders, often tend to get the larger
All right, Mr. Paritosh. Thank you for your
holders often tend to
presentation.
get the larger. Yeah, thank you very much, sir.
All right, we can move with the next participants. Host, we can move with the next participant. Yeah. Host, you are muted. Host, we can move with the next participant. Okay, host is facing some issue. Your
You
voice
can
is not
start
audible.
presenting.
Okay.
Sir, I'm facing some issues like technical issues.
Okay, we can move with AR
Julie, are you
Varavani.
there?
AR Varavani is also there, I
Okay,
believe.
sir.
Yes, we can
I
move
hope
with her.
I'm
I would
audible,
like to
Miss.
invite AR Varavar Mini from Amity Law School, Noida. To present.
Thank you.
Yeah,
I
you are
hope I'm
audible
audible
and
and
visible.
visible.
Yes, you may start your presentation.
Okay.
Ms. Varavani, start your presentation.
I'm trying to. Uh, I hope it's visible.
Yeah, try to slide. Yeah, it's visible. You can start.
Okay, good morning. So today I'm presenting on standard essential patents, the global south and tech sovereignty. The central question I want to explore is this: can countries in the global south ever be more than license takers in a system of standard essential patents that was largely designed and dominated by the global north? This matters because SCPs are embedded deep in the backbone of modern economics, from the infrastructure powering artificial intelligence to clean energy systems to open digital platforms. So, if access to these standards are unequal, then development stalls and sovereignty risks becoming symbolic. So, through this research, I'll be doing case studies as well in order to test properly. So going on to what are SCPs and why do they matter? SCPs are the patents you must use in order to implement a recognized technology standards. Think of it as 3G, 4G, EV charging, AI chips, etc. Uh, while in theory anybody can participate in this, in practice, influence in these organizations follows resources and entrenched power, which tilts the playing field. The promise of FRAND licensing is that it should balance rewards for innovators with fair access to users. But the problem is that FRAND has no single definition. Different courts and regulators apply differently. And that inconsistency creates bargaining asymmetry, especially for smaller firms in developing countries. So at the end of the day, when the rules vary, the strongest players get to set the tone. Now, this brings me to the structural problem that is faced by the South, global South. Firms from these regions generally have little leverage, both in shaping standards at the outside and negotiating licenses later. That means they have weaker voice in design and end up accepting less favorable licensing terms. The result is a dependency loop. They need standards, so they must license. But because royalty terms are often opaque, it is hard to plan national manufacturing strategies or public infrastructure projects. So the bite is sharpest in critical sectors, AI, where chips, networking and deployment protocols are essential. Green technology, where solar grids and EV infrastructure depend on standardized designs, and open source innovation, where even collaborative projects can collide with SEP enforcement. So now I have comparative case studies with three different nations. Uh, in India, cases like Ericsson versus Micromax have shown countries courts sometimes impose interim royalties while disputes drag on. And more recently, disputes such as Interdigital and Xiaomi have highlighted the turn towards arbitration. India has also pushed to build its own footprint in global standards to TSI. Moving on to Brazil, it has relied less on litigation and more on regulatory cooperation, with its competition authority, CAD, and telecom regulator, Anatel, mediating disputes. Policy debates there are now linking SCPs to AI and green tech with attention to patent pools. Kenya, on the other hand, is in a different position. It is less about courtroom fights and more about affordability and access, with solar microgrids and fintech platforms like M-Pesa at stake, and focus on pricing and transparency, with regional efforts through ARIPO, etc., to craft African-centric IP frameworks. When we zoom into the global system, we see broken incentives. Patent pools in sectors like connected cars and video coding can, in theory, simplify licensing, but in practice, they often operate as closed clubs with opaque pricing and participation limited to major incumbents. Then comes the royalty stacking, when multiple SCP holders each charge a royalty. The cumulative effect of each can be overwhelming, sometimes estimated at a large fraction of the final device cost. For firms in developing economies, that can kill competitiveness before they even enter the market. Add secrecy to the mix, and most licenses are hidden behind non disclosure agreements, and it becomes nearly impossible to know what fair and reasonable actually means. Um, Now, to discuss what would a better system look like, where the principle I argue here for is a techno-legal pluralism. So here, instead of assuming one model fits all contexts, governance needs to adapt to different developmental realities. Practically, this means five shifts. First, open licensing registries under global institutions like WIPO, or so that firms know who owns what and under what terms. Second, mandatory alternative dispute resolution as a first step, because it's cheaper and it's more faster across borders. Third, dual standard recognition, so that regional bodies like TSDSI in India can stand alongside giants like IEE and ITU. Fourth, reforms in patent pool governance, giving the global south a seat at the table and enforcing transparency. And finally, a open FRAND approach, where licensing terms are tired or waived for public good sectors like healthcare and climate technology. So the bottom line is that without reform, the global south remains a technology price taker looked out for co-designing in the future. The legal frameworks we rely on must keep pace with the speed of AI, green tech, and platform economics. That means embedding transparency, streamlining dispute resolution, opening pools to diverse players, and recognizing local standards. So, moving this forward requires action three fronts. Scholars must develop better metrics to measure what is truly fair and reasonable. Negotiators and regulators must push for global registries and new pool rules. And courts must treat FRAND as an enforceable standard, not just a slogan. My closing point is simple: it's that technological sovereignty is not just a charity, but for the global south, it's the fairness baseline for participating in the global innovation.
Okay. Miss Varavani, like you had mentioned in various points that the global south should have the technological sovereignty in the SAP. So specifically, when we talk about the global south, what we see the global south is very heavily dependent upon the Western economics for like any of the technological aspect. That can be even this the signaling, from signaling to even like a small to small devices. The global south is dependent upon the Western countries, and what global south is contributing in a global market is the intellectuality, the people who are having the intellect. Western people is having Like, I will not term that they are not having intellects, but they are not having that human resources to contribute in such a way like the global south and the Indian like a subcontinent is contributing in the intellectual levels specifically. So, like, how you can assert that the countries in the global south can have the technological sovereignty within the dominance of SEP holders in AI and green tech? Yes.
So yeah, I understand it's a function of the market dynamics and not a government failure. But the issue is not just economics. I am talking about structural asymmetry here. Market concentration in SCP ownership largely with a handful of multinational firms. It intersects with weak institutional bargaining power in the global south. So it's not a neutral outcome of demand supply. I understand global north sets the standards, and it's about that who defines reasonable in FRAND and who has the institutional representation. So market forces are at play, and they did set the standards at first, but I think it's high time that global south also gets a seat in it, so that this inequality, and we can make the asymmetry the more structural, I guess.
Okay, and there are few suggestions you have to make changes in your paper. Specifically, the analysis is required on the base of economics spectrum of the global south. You have to make a assessment on the technological dependency of global south, and in comparison with the dominance of the SCP, or like you can say I the tech holders of the global south, how many percentage of dominance they are having, they are contributing to the global market. And in that analysis you have to come up with the conclusion that up to how many extent the global south can come up as a technological sovereignty in coming future, and what are the suggestions and solutions associated with it.
That's why I will take the suggestion. That's why I was focusing on AI and green tech, because and globally we all started like together, mostly like the development of AI is going higher and higher like right now. So this would be a factor, a sector in which South can actively contribute to. So that was the gist of my study.
All right. Okay, thank you for your presentation. We'll be moving ahead with the next participant host.
Okay, sir. Now I'd like to invite Juhi Bhutoria from Savita School of Law. Juhi, you can present now.
Thank you, ma'am. I hope I'm audible and my PPT is seen.
Yes, Miss Juhi, you are audible and visible. You can start your presentation.
Thank you, sir. So today I'll be presenting on the research paper, a study on the challenges faced by the Indian startups in accessing SCPs for 5G applications. So basically 5G technology promises faster speed, ultra low latency and massive connectivity, but has its the core of SEP, standard essential patents, which are mandatory for building compliant 5G products. These patents are controlled by a few global companies. Indian startups, despite being innovative, faced high cost, opaque licensing and legal uncertainty. So our study basically aims for three broad questions: the challenges that the startups in India face in SCP licensing, how effective is Indian legal and policy framework, and what lessons can be drawn from the international practices. So the review of literature from the previous review, there's a mixed picture. These highlight the hurdle in emerging markets and why startups often fail, and why are there unique policies and funding gaps, and also how there is a technical evaluation of 5G, and what are the raised environmental concerns. These works gave us a broad base on study of both technical and legal dimension of 5G and SCPs. So overview of 5G SCPs and license ecosystem. SCPs are declared through global bodies like ETSI and 3GGP. The main holders like Qualcomm, Huawei, Ericsson. Licensing is supposed to be on FRAND terms, fair, reasonable and non-discriminatory, but in the practice it is costly and unclear. Patent tools exist, but most licenses are bilateral, creating complexity. For startups, these result in high fees, lack of transparency and also a fear of litigation. The Indian startups landscape in 5G. So India has one of the world's largest startup ecosystem with over like 1,20,000 firms. Startup like Single Chip, Astrom and Nylon Network are innovating in 5G hardware and software. Government schemes such as Digital India and Startup India and the PRL program provide some support. However, none of these directly solve the problem of SEP access or licensing. Key challenges and case studies. The major key challenges that Indian startup face include basically high licensing costs and lack of negotiation power, non-transparent SEP declaration and royalties, limited legal and IP expertise to navigate complex licensing, and there is a threat of litigation. And most importantly, there are absence of national policies and SEPs. For example, in Ericsson versus Micromax case, interim loyalties were imposed by the court, showing how powerful SEP holders are. Similarly, in the Intex case, the Competition Commission had to step in to investigate the alleged abuse of dominance. Single Chip, on the other hand, developed India's first 5G chipset, but even such R&D heavy startups face potential friction when commercializing due to SEP licensing hurdle. These cases highlight the real-world impact of the SEP ecosystem in Indian innovators. Next, policy and legal framework in India with comparison to comparative analysis. In India, the Patents Act 1970 governs patents, but it does not define SEPs separately. The Competition Act 2002 allows the Competition Commission of India to intervene in the cases of the abuse of dominance, as is done in Ericsson's dispute, but overall, the policy environment is fragmented. When we see in abroad, the European Union, the Huawei vs ZTE case judgment created a structured FRAND enforcement system. In China, specialized IP codes and anti-monopoly rules actively protect startups. And also in US, FRAND issues are handled through antitrust and contract law, but still litigation dominates over there. Compared to these jurisdictions, India lacks clarity, consistency, and support mechanism for the startups in SEP ecosystem. The recommendations are codifying FRAND licensing principles into India law, establishing a national SCP licensing and mediation authority, strengthening oversight by the CCI and TRAI, launching a SCP legal aid and platform for startups, promoting Indian participation in international standard setting organization, developing domestic patent pools or open licensing platforms to make Atmanirbhar Bharat, encouraging endogenous standards like FGI, 5GI, and finally creating financial support through schemes such as royalty subsidies or IP insurance for the startups. Together, these steps could make SAP access more equitable and innovation friendly. In conclusion, while 5G promises transformative benefit, the SAP ecosystem is highly exclusionary, dominated by a handful of global patent holders. Indian startups face significant obstacles, as I first mentioned, by adopting structured frameworks like those in EU and China, and by implementing our recommendations, India can ensure the SEP access becomes a bridge of innovation rather than a barrier for Indian startups. This will be not only for crucial, only for 5G, but also for the upcoming 6G ecosystem. Thank you.
Okay, Miss Juhi, I have one specific question for your presentation.
Yes, sure.
Specifically, you had mentioned there is a clash between the Indian startup which facing negotiation when the fraud licensing, like specifically for the 5G SAPs. Like, how do you think this barriers, specifically the barriers of trade, like with the multinational corporates for these startups? Is hindering the Indian economics when it comes to the licensing.
Yes, sir, that's what I said. It's hindering the Indian economics, and the 5G applications which are started by the Indian startups are not able to face. And as the MNCs, the global powers, have more patent and SCP licensing, so India suffers over there. That's why I have given recommendation on basis of creating SCP rules and regulation, FRAND licensing and policies. This would help Indian startups, whereas MNCs are still in growth while Indian startups lag because they don't even have proper funding and there is a lot of gap in litigation.
I'm asking you, like, do you have any sort of statistics where there are reports where the Indian startups are facing such clash between the MNCs or multinationals?
Okay, sir. So there is no specific reports, but companies have given out by stating the cases. As I said, in a single chip case, single chip is basically a new startup in India where they developed 5G chipset. But because they did not have the SEP and proper licensing, which was not provided by the Indian government, they were not able to come out with the 5G chipset, which was later taken off by China and USA. But it was developed in India.
Okay,
So I
all
have no
right.
specific reports which I have gotten through, but I have gotten through the company's case law, sir.
So take this suggestion, search some of the reports. Specifically, you will get reports on WTO, and also the WIPO has some reports where the startup and multinational like statistics are published. All those are in public domain. You
Okay,
can
sir.
research upon it and include it in your study.
Thank you, sir. Okay, sir.
Okay, all right. Host, we can move with the next participant. Okay, the next participant specifically Vineet, are you present?
Uh,
Okay, yes, you may turn on your camera.
sure, sir. Just so I hope my PPT is visible to you.
Yes, your PPT is visible. Try to slide.
Yes, sir. So, good morning, sir. My name is Vineet, and I'm student of National University Nagpur. My topic of research is protecting industrial design in the fashion industry. So, as we know that in with respect to industrial design, there are a lot of challenges and emerging trends and legal reforms which has emerged due to advent of AI and in this digital era. So, in this presentation, I'll be exploring all the complexities which are related to fashion designs and which is against piracy or replication counterfeiting, which is so much evolving due to advent of AI. So in this research, I have basically dealt with defining the fashion in visual identity, international and national approaches, global design protection comparison, the new challenges which has emerged due to advent of AI, the battle against piracy or replication, and shaping the design protection and landmark decisions. To begin with the dynamic world of fashion IP, so as we know that fashion industry thrives on creativity, but it faces so many challenges with respect to unauthorized replication and fast fashion exploitation. The digital era with social media, e-commerce, and AI has accelerated coping, while global markets complicate the enforcement. So, in order to understand what industrial design means, it means the aesthetics or ornamental aspect of an object. It includes the visual features such as shape, configuration, pattern, or ornamentation which are applied to a product. These features makes the product visually appealing or distinctive, and they are protected under the industrial design laws, which are different for each jurisdiction, whether it's US, European Union, or China, or we can say India as well. So in this research, I have found a lot of research gaps. So I'll be dealing with comparative legal analysis of different jurisdiction. So the main methodology which I have taken for this research is doctrinal analysis, where I'll be analyzing the statutory frameworks of different jurisdiction and international agreements like TRIPS,
Mr.
Hagel
Vineet,
Agreement.
your slides are not moving.
Sir, now is it?
No, it's not moving.
Sir, still it's not.
Just go back in the slideshow. Like no need to slideshow. It's just simply present scrolling down. It will work. Yeah,
I hope it's fine, sir. Now,
yeah, it's fine. You can go with the challenges and solutions.
sure, sir. So basically, first of all, the main challenge which we are facing nowadays is AI and you know the piracy issue. So there are so many tools like DAL-E, which raises question on ownership and originality, and it leads to complication of IP rights. Secondly, we have the advent of fast fashion, which has came just now. With respect to rapid replication by brands like Shein and Zara, which makes legal recourse ineffective due to the speed. Thirdly, sustainability. We know that This concept is a bit new in the fashion world, that nowadays all the people are talking about sustainable fashion. So eco-friendly innovations, they often lack adequate legal protection, and sometimes it's lead to IP infringement as well, which discourage the investment. Fourthly, we have blockchain and NFTs, which raises potential solutions for digital ownership and authenticity. Therefore, enforcement is very tough in this aspect. Uh, Moving on to battle against replication. So the basic idea behind this research is that highlighting the core issues. Firstly, it is costly litigation, because as we know that most of these brands, they are dealing with only the famous brands like Zara or Gucci for that matter. But those designers who are on boutique designers, or who are not on that large scale, so they face so many challenges with respect to litigation aspect. Their designs are easily pirated and copied. Secondly, counterfeiting. So a multi-billionaire dollar industry, which exacerbated by e-commerce platforms, they underscore the limitation of traditional enforcement. This leads to a lot of challenges. Thirdly, we have creativity versus protection. So balancing legal protection with artistic freedom remains a contentious issue in the fashion law. Moving on to the landmark battle. In this research, I have taken four landmark case laws, which I have dealt in detail in my paper. Firstly, Louboutin versus YSL, where Red Soul trademark protection was contrasted with other shoe colors, and it emphasizes with trademark versus design. Secondly, Star Athleisure versus Veracity brands, where cheerleading uniform designs copyrightable if separatable from functional aspects, which blur the IP boundaries. Then Gucci versus Forever. This case is very landmark because it decided on the settlement of strip designs, where Gucci has basically copied from Forever 21. It highlighted difficulties in proving distinctiveness of the common element. And then the last case is Adidas versus Skechers. Uh, with respect to moving forward and concluding it, we therefore basically suggestions which I would like to provide and by this research. First of all, we need to simplify the registration process. There should be less complexity, less time consuming things, and the cost for designers should also be less, because there are so many boutique designers who face these challenges. Secondly, there need to be collaborated approaches, and strengthening the cooperation should be there, because the VPO's role should come and their objective should be fulfilled. Thirdly, it should combat the counterfeiting, because leveraging AI and blockchain, which holds the online platforms accountable at the end of the day. So these things should also be combated. And fourthly, promotion of self-regulation, because industry association can set high standard and guide ethical practices. So with this, I would like to conclude. Thank you, sir.
Okay, Mr. Vinith, like how effective are current industrial design laws are present in addressing fast fashion replication and digital piracy? Specifically, when we talk about particularly the rise of AI generated designs and
Hmm.
online marketplaces.
Sir, currently with respect to different jurisdiction, firstly, if I talk about India, so India has Designs Act 2000. So there are not much changes which have arisen, because these AI and these things have came post COVID. So that's why there are not much changes which are available to our laws, and that is where my suggestion lies, that there should be some amendments should be made, and there should be certain guidelines which basically support the designers in that matter.
Okay, all right. Thank you for your presentation.
Thank you, sir.
We will move ahead with the next participant. Present here, Aditya Deshmukh from HNLU Raipur. Okay. Yes, Aditya, you may present your screen.
Yes, sir. Sir, is my screen visible?
Yes.
Good morning, sir. Myself, Aditya Deshmukh, and my co-presenter Harsh Baskwa, a third-year law students, we'd like to present our paper titled Royalties, Rights and Regulation, Decoding Patent Pools in the High-Stakes Global Innovation Race. The first half of the presentation will be dealt with by me, after which my co-presenter will take over. To begin with, we often hear with companies spending a lot of their amount in research and development uh, and while exceeding this amount with respect to their expenditure in IP litigation. For instance, in 2012, giants like Google and Apple faced scrutiny for outspending research and development on patent related expenses. Patents are like a double-edged sword. While they grant crucially exclusive rights, protect R&D, and allow companies to recover their costs through royalties, their filing process is extremely lengthy and expensive, while overly broad patents stifle competition, resulting in creation of monopolies. These challenges highlight for something which we know as patent pools. What exactly are patent pools? The World Intellectual Property Organization defines them as a kind of an agreement between two or more license holders to license one or more of their patents to any third party within or outside the group. In essence, they simplify the entire landscape of patents. Their advantages are quite significant, such that they streamline complex licensing processes, help companies avoid endless negotiations, and dismantle something which we know as patent thickets and the tragedy of anti-commons. They typically function by making a collection of patents available under a single license, wherein the fees is distributed among the patent holders. Looking at the real-world applications of patent pools, they have seen remarkable success as well as miserable failures. For instance, the MPEG patent pool, which handles patents crucial for audio-video compression, is one which was extremely successful due to the fact that its formation drastically reduced litigation, simplified licensing, and led to widespread adoption of these technologies, which propelled rapid development in the industry. However, not all initiatives thrive. The Eco Patents Common focused on green tech. It failed due to a lack of market knowledge, poor publicity, and a failed funding model, which was voluntary in nature, which led to insufficient funds. These cases underscore that while potent, patent pools requires careful strategic planning. Now, patent pools have the power to influence the global markets. Due to this, they require significant and systematic regulation. This prevents issues like royalty stacking and ensure fair competition. Globally, standards like the TRIPS agreement by WTO ensure minimum IP standards. While the World Intellectual Property Organization does not directly regulate patent pools, it provides a vital discussion on IP and antitrust. At a national level, countries like the US, EU, and India subject patent pools to strict competition laws. These scrutinize agreements for anti competitive elements, ensuring that royalties are reasonable and the terms are fair. In essence, herein, the key is to make IP market more accessible, less complex, and a true aid for futuristic innovations. Now, I'd like to invite my co-presenter to continue with the presentation from here on.
Sir, I am audible. Good morning to the esteemed panel. My name is Harsh, and now I will continue the presentation. So, when we talk about royalties in patent pools, the first question is simple. How do we decide who get what share of the pie? So, different methods exist. First is the royalty percentage method. Second is the cost-based model. Third is the essentiality assessment model. But after examining multiple approaches in our paper, we found out that technical contribution assessment model stands out because it values just not revenue but technological contribution, area of application, and business potential. In short, it rewards quality, not just quantity. Similarly, in distribution, while both usage-based model and proportional models are applied, but we argue that proportional distribution better incentivizes innovations since it reflects the quality and quantity of contribution rather than mere usage. Coming to our next topic, which is relationship between antitrust regulation and patent pools. On one hand, they reduce cost and make innovation more accessible. On the other, they risk creating cartels and raising barriers for new entrants, facing a paradox. To strike a balance, we recommend regular review of patent pools to ensure compliance, Secondly, application of essential facility doctrine to stop dominant firms from suppressing the competition. Thirdly, embedding FRAND licensing terms to ensure fairness. And lastly, setting up an independent governance framework so that oversight is neutral and credible. The idea is to transfer compliance into reputation, making patent pools not only lawful but trustworthy vehicle of collaboration. Now let us step into the perspective of Global South. For many developing economies, there is a limited access to technology and less research facilities, which is coupled with brain drain and high cost, and has slowed the social economical progress. Patent pool offer a bridge across this divide, and case studies in India and Africa show us that well-designed patent pool firstly can reduce the financial burden on local manufacture. Secondly, accelerate the adoption of modern technologies. Third, promote domestic industries and job creation. And lastly, foster a sustainable culture for R&D. But this requires action, and government must identify the technological gaps. Secondly, they should work on building a transparent framework, and lastly, they should collaborate with global institutions like DPO, which will provide a neutral framework for technical and funding assistance. This is not just charity, it is the investment in a more balanced global innovation order. Now let us look ahead. The innovation landscape is shifting, but the patent pools have mostly thrived in the tunnel of tangible innovation. We now face the question in areas like cryptocurrency, AI inventorship, biotechnology, and climate tech. But the central tension remains between profit versus public good. How do we balance it? So some forward-looking solution includes: first is real-time licensing and dynamic pricing to adopt a fast-changing market. Secondly, blockchain-enabled patent pool management for transparency and accountability. And lastly, automated royalty distribution system, ensuring fairness across vast pool of contributors. At the end, the rigid and slow-moving laws should be modified rather than becoming a relic of bygone eras. Now, to conclude, the patent pools are not panaceas, but when designed with fairness and foresight, they can simplify the licensing. Secondly, lower the cost of transaction. Thirdly, resolve the patent tickets, and most importantly, they transform IP barriers into bridges for innovation. But this is possible only if we embed robust governance, friend terms, and independent oversight and constant compliance with the reviews. The message is clear. Patent pools are not about weakening competition, they are about reimagining collaboration. When regulated wisely, they can power an inclusive, innovation driven economy. Thank you.
Okay, so team, there is one question from my side. How you can like how you can assess the regulatory framework can have a balanced approach and in innovation patents through patent pooling and also preventing their misuse as a tool for anti-competitive royalty stacking in global innovation market.
Sir, we have to look into the different types of contracts, and we need to review the contracts of licensor, licensee, and public administrator contracts of the patent pools for this.
So specifically, our Indian competition law is having that scope to look into the patent pools.
Sir, India, like in India, the licensor and licensee agreement can be looked into. But what about the public administration? This is a loophole, and this should be modified.
Okay, and what are your take on the royalty staking?
So royalty stacking basically occurs due to improper regulation, such that there are no proper guidelines which ensure proper royalty distribution. While we did highlight in a research paper that there are certain uh, procedures or formats or models which may be used to distribute and determine the share of royalties. However, due to lack of guidelines, royalty stacking results in overly bigger entities uh, taking a large
Sir,
share
it
of the
lead to
entire royalties
suppression.
with respect to patents.
Sir, that's why we have recommended the technical contribution assessment manual, which stand out and which solve this problem.
All right. Thank you for your presentation.
Thank
Thank
you,
you,
sir.
sir.
We'll be moving ahead with the next participant, Kavya Sri from VIT School of Law, Chennai. Yes, Miss Kavya, you may turn on your camera and unmute
Yes,
yourself.
yes. Can you, am I visible?
Yes, you are visible and audible.
Yes, sir.
You can start your presentation.
I'll share my PPT.
Yes. Yes, yes, screen is visible. You can open your
Uh,
PPT.
yes, sir. Just a minute. Yeah. So, good morning to respective dignitaries, professor, colleagues, and fellow participants. I'm Kavya
Miss
Shri, and I'll
Bhavya,
be.
your PPT is not visible. Your PPT
Uh,
is not visible. It's only your screen which is visible.
can you see it now?
No, it's only the screen of the StreamYard is visible in your.
Okay. Just a minute.
Kindly be fast.
Yes, sir. I'm so sorry for the inconvenience. So it's being processed. If you don't mind, can I start with the presentation? The present PPT is being loaded here. Yeah.
Okay, you can start your presentation. Like I believe your PPT is visible
Yeah,
now.
it is being shared here.
Okay, yes.
Yeah. So, good morning to one and all. So, I'll be presenting on the topic balancing patent protection and access to medicine. So, so this presentation looks at one of the most pressing issue in the field of intellectual property and public health. How do we balance right of pharmaceutical inventors and with ethical imperative of ensuring access to life-saving medicines? So the pharmaceutical patent system grants inventors exclusive right for 20 years, right? Well, this is an intent to encourage innovation and allow to recover R&D costs. It also often results in exorbitant drug prices, especially in developing countries like India. So the TRIPS agreement adopted under the WTO agreement made patent protection mandatory for member states, including pharmaceutical. So this created a conflict on one hand, the in incentivizing pharmaceutical research, and other hand, the restriction to access essential medicine for millions. So the key tension we explore here is how can innovation be protected without sacrificing on public health need. Uh, to address this conflict, the TRIPS agreement included Article 31, which allows government to issue a compulsory license. So this means a country can permit the production or use of a patented drug without the holder's consent, providing certain conditions are met. So such as it includes fair remuneration to the patent holder. So we have the Doha declaration, which reaffirmed that trips should not hinder member from participating from protecting public health, and declare explicitly that public health takes procedure over IP rights. So further, we also had Article 31 BIS, or the paragraph 6 of paragraph 6 mechanism, which allowed compulsory licensing for export and enabling countries without manufacturing capacity to export generic other forms from other countries. So, however, in practice, this mechanism has been criticized for being too complex or too rarely used. So in India is a classic example of balancing IP and public health. Before TRIPS, India only allowed process patent, right, which help to create a robust generic drug industry. So post TRIPS, the 2005 Patent Amendment Act aligned Indian law with a global standard, but retained Section 84, which allows compulsory licensing in this country. So we had a landmark judgment called the NATO versus Bayer in 2012, involving a cancer drug called Nexavar. So Bayer priced the drug at 2.8 lakhs per month, making it unaffordable for most of the patients. So NATO Pharma applied for a compulsory licensing, and Indian Patent Office also granted it. So this led to 87% of price drop, bringing the monthly cost to 8,800, while NATO paid Bayer a 6% royalty. So this case became a global precedent, demonstrating how developing nations can effectively use TRIPS flexibility to prioritize public health. Although subsequent application for compulsory licensing were denied, this case remains a benchmark in international pharmaceuticals. Okay, so yeah. Brazil's approach was more strategical and political. Its 1996 industrial property law provided grounds for compulsory licensing, but instead of using it frequently, Brazil used the threat of compulsory licensing as a negotiation tool with multiple companies. During the HIV and AIDS crisis, Brazil instead insisted on providing universal access to antivirusable drugs, and pharmaceutical companies price these drugs extremely high. So Brazil negotiated price reduction by threatening compulsory licensing and saving
Miss
millions.
Kavyasri, just go to the recommendations and
Okay.
solutions.
Can I go to the conclusion part, or okay. So in COVID-19 pandemic highlighted deep inequalities in the global health access. While some countries had vaccines, others struggled even to get supplies. Right. So India and South Africa processed a TRIPS waiver in 2020 to suspend certain IP rights during the health crisis, though the outcome was limited. Going forward, reform must include simplifying procedure for compulsory licensing, encouraging regional comparative through institute like African Medicine Agency and PAHO strategy fund, building local manufacturing capacity for APIs and generics, building local manufacturing companies for yeah, enabling a human rights based approach into patent law, aligning with the UN Sustainable Development Goals. So, I'll be concluding this presentation. To conclude, compulsory licensing remains one of the most vital TRIPS flexibility available to developing countries. So, India's Nexaway case showed a legal boldness, and Brazil's licensing to the similar to the compulsory licensing displays political strategy. So, South Africa, which I didn't cover, has constitution litigation highlighted the role of human rights. Yet, challenges persist from administrative complexity to global political pressure. The key lesson is that public health must take precedent over market monopolies. The pandemic reminds us the access to medicine is a human right, not a privilege. So, going forward, compulsory licensing should not be seen as an exception, but as a standard instrument for public health policy in global south. Thank you. So
Okay, Miss Kavyasri, like how do you understand the compulsory licensing provisions and TRIPS flexibility operates differently across different jurisdictions, and
Yeah.
to what extent have they succeeded in balancing patent protection with public health imperatives?
Yeah, let's come to Indian perspective. So in India we don't get access to many drugs, right? Let's take the example of Nacto versus Bayer. So Nacto versus Bayer was a case in which we didn't get access to cancer medicine. So compulsory licensing was granted to the Nacto pharma by the government. It was like a license given to the pharmaceuticals by the government to produce and manufacture generic medicines in a lower cost. So similarly we have compulsory licensing. Similar to that, other countries have like Africa has Africa, no, I mean Brazil has FNZ's license. So other countries have developed similar mechanism to similar to the compulsory licensing.
All right. Thank you for presentation.
Yeah, thank you, sir.
The next presenter we are having Miss Yana Shipa Topo. Okay, Miss Anna, you
Yes,
may
sir.
turn on. Yes, you may just present your screen and share your presentation.
Yes, sir.
Be fast, Miss Yana.
Yes, sir. It's being presented. It's processing. So the file is being uploaded.
You can start your presentation. Once it get uploaded, it would be reflecting in the.
Okay, sir. So good morning, everyone. And today I'll be presenting on. Sir, is it visible now? Is it there? Yes. So today I'll be presenting on discriminatory FRAND licensing and market exclusion, a competition law assessment of SEPs in India. And this topic is important because it is in the intersection of patent, technology, and competition law in India. Uh, Firstly, um, in today's digital world, technologies like 5G, smart devices, AI rely on shared standards, and patents that are essential to these standards are called SEP, Standard Essential Patents. And these must be licensed on FRAND terms, that is, fair, reasonable, and non discriminatory. But in India, enforcing FRAND is a challenge. We don't have clear law defining SEPs or FRAND, and recent court ruling have limited the CCI's role in India. Therefore, I have two main research questions. Firstly, does the absence of statutory FRAND licensing guidelines in India enable SEP holders to impose discriminatory terms? And secondly, what lessons can India draw from global regulatory framework? Currently, India has a regulatory gap. That is, the Patent Act does not address SEPs directly. There is compulsory licensing, which exists, that is Section 84, but it is time taking. And then CCI, which tried to act under the Competition Act, but Delhi High Court ruled that SEPs come under the domain of patent law and not competition law. Therefore, this makes it, and also Unlike Europe and Japan, India has no standard process for FRAND negotiations. Therefore, this makes it especially hard for MSMEs who face high costs and unequal bargaining power. Moving forward with the discriminatory licensing and abuse of dominance, when a patent is essential to a standard like 5G or 4G, the patent holder gets huge market power, dominance, and therefore CCI had recognized four legal issues. That is, firstly, the charging royalties on the entire product instead of just the patented component. Secondly, giving different terms to the similar companies, and thirdly, forcing the companies to sign NDAs, that is, non-disclosure agreements, and thirdly, requiring the disputes to be settled in foreign courts. And then I have discussed the case laws. Firstly, in Ericsson versus Micromax, royalties were demanded based on the full device price. In Index versus Ericsson, NDA and high royalties were challenged. And in iWall versus Ericsson, concerns about foreign arbitration and litigation threats were raised. So, finally, in 2023, Delhi High Court ruled that CCI cannot investigate these issues, and this left is SEP licensing issue mainly to civil courts, and which focuses more on patents than on competition. Uh, then there are comparative perspectives. Firstly, globally, we can see how different countries have their approach. In Europe, UI versus ZTE established a framework for negotiations. SEP holders must first negotiate fairly before suing. And then in United States, uh, there is a policy inconsistency. Sometimes it favors the patent rights, and sometimes it favors the uh, competition market. And then we and then there is Japan, which has clear guidelines for good faith licensing negotiation, and these models can help India adapt those models and create a balance. Then I have discussed about the market access and the innovation challenge in India. That is, in India, SEP licensing can create barriers. Firstly, the royalty is being charged on the entire product, and then the NDAs and the foreign clause for settling the disputes can be very costly for the small startup and innovation companies. And therefore, without the reforms, local innovation will be stifled. And so I have come up with a few recommendations. That is, what we can do. Firstly, we can create a structured negotiation protocols as laid down in the EU's case law framework, requiring good faith offers, response, and other things. And then implementing Japan's approach, that is good faith licensing guidelines. Uh, Thirdly, a patent pool. So MSMEs can get one-stop licenses instead of facing multiple complex negotiations. And then lastly, build an SEP registry. That is, develop a central SEP database with essentiality checks and encourage voluntary disclosures as per the following the proposal of European Commission's 2023. Therefore, the key to sum it up, India's current framework is weak and mostly favors the patent holders, and practices like royalties on the entire devices, NDAs, and forum excludes smaller Indian companies. And then other countries provide useful models, but and through those models, India can adapt them in the Indian market, and strike a balance between patent right and the market access. Therefore, in conclusion, I would like to say that SEPs should not become tools of exclusion. Instead, with the right reforms, structured negotiations, transparency, and fair licensing, India can build an ecosystem that supports both innovation and inclusion. And this will ensure SEPs become gateways to both growth and collaboration, and not barriers for them. Thank you.
Okay, Miss Yana, like to what extent you think that India's Competition Act addresses or like equally comes up with the provision of discriminatory fraud licensing practices by SB holders? Can the CCI act upon such kind of discrimination?
Oh, see, as ruled recently now in 2023 judgment, where CCI is not having the jurisdiction. There is a basically there's a dispute in jurisdiction itself that whether it should be a patent domain or whether it should be a competition law domain. So if there is a sub ecosystem to balance both the things and can have jurisdiction in equal both of them, both the regimes can have equal jurisdiction, then they can what they can do is competition commission can assess the market analysis or the um, just the such as the relevant market which they can determine, and then the SEP holders, those who are holding these SEPs, can also have give out the licenses in such a way that it is not they are not abusing their dominant position as well. So that's
Okay,
it.
so
Sorry.
Competition Act, according to you, can cater under these SAPs and technological domain under Section 3 and 4.
Uh, yes, maybe because it depends on the their yes, sir, maybe
All right, Miss Yana.
because there's
Thank
a
you for this.
jurisdiction clash. Yeah, thank you, sir.
Okay, thank you for your presentation. We'll be moving ahead with the next participant. Akhilesh Singh, are you present? Okay, Harini R.
Yes,
Harini
sir.
R. Yes. Turn on your camera and unmute yourself.
Yes, sir.
We'll be moving ahead after Miss Harini, Akhilesh Singh, and Omkar Gaurav.
So is my screen visible?
Yes, your screen is visible. You can start your presentation.
Okay, sir. So good morning to all the dignitaries present here. Myself, Harini. Today, I will be discussing the licensing challenges between standard essential patents and open source software in context of digital platforms. To begin with, let me give a brief background about the SEP and OSs. So, SEPs are patents held by pioneer companies that invent and develop technology. These companies expect to be paid for their inventions because they put in significant effort and investment to create them. Their intellectual property should be protected, but at the same time, SEPs allow other companies to build standard interoperable technology. On the other hand, OS's license work differently. They allow anyone and everyone to access the software without paying. For example, the General Public License or GPL lets you change the code and use it, but you cannot commercialize it. The Apache License 2.0, however, permits usage and commercialization but comes with patent clauses. Similarly, the European Union Public License or EUPL also governs OSS. The idea behind OSS is collaborative innovation where communities collectively contribute and improve technology. This contrast between SCP, which emphasizes protection and fair payment, and OSS, which promotes openness and collaboration, often leads to challenges, conflicts, and the need for balanced legal frameworks. like fair, reasonable, and non-discriminatorily license. My methodology involves descriptive analysis, qualitative analysis. Moving on with my compatibility and conflict SEP licensing versus open source software models. As I already mentioned, SEP are usually licensed under FRAND terms, which aim to strike balance between rewarding innovation and ensuring broad access to technology. In contrast, open source software or OSS works on completely different principle. Its license, such as GPL and Apache, emphasize free use and royalty-free distribution. This difference often leads to tension. For example, when an open source project needs to implement a standard that falls under an SEP, the royalty or negotiation obligations under FRAND directly conflict with free redistribution model of license like GPL. So there is a legal deadlock between these two. Uh, Judicial and regulatory approaches to SEP OSS conflicts. As in the EU, the Huawei versus ZTE case set a roadmap before SEP holders can get an injunction. They must show they negotiated fairly on FRAND terms. And in the US, cases like Microsoft versus Motorola and FTC versus Qualcomm show very different approaches to what counts as reasonable royalties. In India, in Ericsson versus Intex, the court upheld FRAND commitments but still granted injunctions, making life difficult for developers. Policy and licensing reform towards harmonization of SCP and OSS. Again, the reconciling SCP exclusivity with OSS freedoms requires reforms like patent pledges, FRAND compatible, open source license. So, I would like to move on with my suggestion. The first one would be hybrid licensing models. For example, dual licensing where SCP holders provide both FRAND and OSS compatible options. And the second thing would be patent pledges where companies promise not to enforce their SCPs against open source developers. And the third thing would be updated policies in standard setting organization to better account for the role of open source in modern technology. The fourth suggestion would be even royalty-free patent pools, which could allow standards to be implemented freely in OSs while still rewarding patent owners collectively. Moving on to conclusion. The ultimate goal is not to choose between SCPs and OSs, but to create a system where both can coexist, protecting inventors while still fostering collaboration, openness, and sustainable technological process. Thank you.
Okay, only one question I'm having for you. How can the
Yes.
conflicting obligations of FRAND licensing for the SCPs and the royalty-free nature of open source software be coincide in the digital platform without determining innovation and interoperability?
So can you come again?
Like, how can the conflicting obligations of FRAND obligation for SCPs and royalty-free nature of open source softwares be reconciled in digital platforms without determining innovation and interoperability?
So as we said, when an inventor is given SCP, which means that it is their patent, and by giving hybrid licensing models, it provides SCP holders both FRAND and OSS compatible options.
Okay, so according to you, the OSS compatible options are also applicable in the SCP models when it comes with the
Yeah.
interoperability.
So if they compile the FRAND to the OSS, like if they make a new framework, then it could be a better option, sir.
Okay, so take my suggestions specifically in the FRAND licensings. There are very limited scope in the royalty-free nature of open source softwares. So you can make a analysis upon this that up to what extent there is a like a FRAND licensing limitation, or up to what extent the royalty free nature can be provided to the open source softwares, and the assessment should be
Okay.
made accordingly, comparing both the natures and the FRAND licensing terms.
Okay, sir.
Yeah, all right.
Thank you. Thank you.
Yes, now we'll be moving ahead with the group Akhilesh. Yes, Akhilesh Singh and Omkar Sivaji Gaurav.
Yes, sir. So are we visible?
Yes, you are visible and audible.
Yeah, we'll be presenting our screen right now. Myself, Omkar, and this is Akhilesh. Thank you so much for the opportunity. I'll be presenting with the presentation now. I'll start sharing my screen.
Yes. Your screen is visible. You
So
can
is the
start your.
screen visible?
Yes, it's visible. You can start the presentation.
So our topic is SEPs and the future of innovation, and we are focusing on three major touch points currently: AI, green technologies, and digital platforms. This is the framework which we'll be following while presenting it. First, we'll talk about what patents and SEPs are. Then we'll talk about how they've evolved over time and what is their importance currently. Then we'll move on to the sectoral applications like we discussed about AI, green technologies, and digital platforms. And then we'll talk about the challenges and the way forward. So I'll be starting with what patent is. As we know, patent is a type of a license-based monopoly over a new invention, and in India, it is provided for 20 years under the Indian Patents Act, which provides exclusive rights to inventors, which also includes monopoly rights as well as licensing rights. Coming like deriving from this, we have the standard essential patents. So before that, let's talk about standards are technological and industry standards which are usually governed by certain organizations which are known as setting organizations, SSOs, or standard development organizations, SDOs. Some of these include ETSI, IEEE, ITU. They operate on a national level as well as on an international level, and what they do is they basically set up standards which can be used by patentees, wherein the patentee gets exclusive royalty rights but is also obliged by the FRAND framework to share the technology with other stakeholders so as to ensure smooth interoperability between various domains. And we can see one example of standardization in it's basically prevalent in ICT. One of it is Wi-Fi, 3G, text messages, so which has helped the common man as well as various players in the industries to make sure that these technologies are shared by everyone and innovation is driven forward in a seamless, uniform direction. And currently, these SEPs are, whenever they are being set up or developed by an SDOs, they come under the FRAND terms: fair, reasonable, and non-discriminatory terms. So what happens is when a FRAND term is being implemented, it ensures fair competition in the global marketplace, and this would help a proper interoperability between certain domains and technologies. Moving on, let's talk about historical evolution of standards. So standards, as we know, are not a thing of this century or even like this decade. They have been existing in India and in the world since the ancient times. Like the simplest example we can think of are the Harappan bricks. All of them were of a similar standard, a similar ratio, so to say, and it helped in creating a city, or rather a development of a proper civilization. Along with this, we have the example of railway gauges laid down by the British and all the infrastructure that followed after that. Modern SCPs, like we discussed earlier, include Wi-Fi, Bluetooth, USB-C, 5G, and now we are also moving on to different platforms. Like let's say in digital platforms, we have uh, the payment systems, the payment gateway systems, banking operations. All of these have been using standards and benefiting people. Like for example, in India itself, we have 1.99 billion recorded telephone users as of March 2024. And if operated properly, we can ensure innovation and fair access across ITC as well as other sectors. Now, let's talk about SEPs in AI. So we have noticed that AI has been growing in the past decade, and since 1950, around 340,000 AI-related inventions have been patented, most of which have been done after 2013. When we talk about the patent growths in AI itself, 28% of patents have been sorry machine learning patents have recorded a 28% annual growth rate, and there are certain players like Baidu, Alphabet, Siemens, Microsoft, Samsung, who are leading and dominating in the field of AI innovation. So what we see right now is that AI is prevalent in almost each and every sector that we are using today. So with this comes like a new set of challenges, like there are antitrust issues and complex royalty stacking problems. There is a fragmented national framework across regions. Like for example, India would have a different national framework, US would have a different framework, and this also risks the smaller players into imposing standards on smaller players to follow the standards set by all the bigger leaders and the dominating players. To tackle this, we suggest like a proper structured framework which would be accessible to everyone and ensure equitable participation, one of which is the MPAI, which is moving picture audio data coding by AI, which has been a great non-profit initiative. Moving on, let's talk about the green standards, where eco patent commons, green exchange, these were the two uh, we can call initiatives which have been existing since 2008. They are not operable right now, but we can take influence from them, we can take inspiration from them, and create patent sharing and royalty free licensing, or like FRAND licensing to green initiatives, particularly in the transport or the
Team,
irrigation
move to
sector.
the suggestions and recommendations and try to
Sure, sure.
conclude in 1 minute. Yes.
Sure. So the way forward is we should have a global SEP framework under WIPO or WTO, including soft law instruments. Then patent sharing should be available, and we should revive the earlier models with proper legal backing and support. Then all of these should be aligned with SDGs and Paris Agreement for a proper sustainable development, and collaborative information and a stronger ADR system is recommended, highly recommended, or rather is imperative to ensure a proper and seamless way forward. So, collaborative future is the future of SEPs. Thank you so much.
Environmental sustainability.
Okay, so team, like how can a legal and policy framework governing SCPs be adapted? I'm asking you the framework. What type of framework can be adapted, like in order to determine that the rapid innovation in AI and the green technology, specifically the digital platform, which is hindering the restrictive licensing practices and royalty stacking.
Uh, so, can you repeat the question?
I'm asking you what are the types of policy framework or the governing model can be adapted to ensure that there is no restrictive licensing practices or loyalty stacking, which is done by the rapid innovation platforms, specifically on AIs and green technologies and digital platforms.
Right. So, first of all, we can have like a global SEP framework under WIPO or WTO. Then we can have a proper set of FRAND guidelines which are well defined, transparent, and equitable for royalty structures. After that, we can have proper international arbitration tribunals specifically set up for these, like a fast track system, and we can also have patent pools and open licensing to reduce monopoly.
And public-private collaboration for the SMEs.
Yeah, right from the academic to the institutional levels.
So one like thing you should add in this particular paper, specifically talking about the policy framework, there are various suggestions which WTO along with WIPO has provided time to time in various publications. You
Right,
can
right,
go
right.
through the recent publications on SEP and their suggestions and recommendation, and can include those suggestions and recommendation along with your suggestions in the policy framework segment of your paper.
Sure, sir.
Sure,
Sure,
sure. Yeah.
sure. Thank you so much, sir.
Thank you,
Thank you
sir.
so much.
All right. Thank you.
Thank you, sir.
Now we'll be moving ahead with the next participant, Adora from School of Law, Christ University.
Am I
Yes, you
audible,
are.
sir?
Yes, you are audible and visible. You can share your screen.
All right, sir. I'm not able to do that. Just a moment. Anika, is my screen visible, sir?
Yes, 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 screen is visible.
Yeah. Thank you so much, sir.
You can start your presentation. Yes.
Yes, sir. Much. Thank you, sir. Good morning, everybody. I am Adora, and I'm from fourth year School of Law, Christ University, and I'm very grateful to have been given this
Adora,
opportunity.
try to be little louder. Your voice is not audible. Try to be little
Yes,
louder.
yes, sir. Sure. So, am I audible now?
Yes, you are audible. Be little louder. That's fine.
Yes, sir. Yes, I'll do that. Good morning, everyone. I am Adora. I'm very grateful to have been given this opportunity to present on FRAND and transition towards equitable and transparent SEP licensing, which is my title for my paper. So, as everybody already knows what standard essential patents are, um, even if I, from a developing country like India, want to build something like a smartphone, I require certain technologies to make it work, such as 5G, Wi Fi, and Bluetooth. However, the owners or the makers of these particular technologies have patents, and these patents essentially form a part of standard essential patenting. There is a possibility, and it is the reality, that these patent holders are free to charge whatever they want just because they can, because they hold the monopoly over these particular patents. And the entire idea of FRAND licensing is to regulate this. However, in reality, this barely or very rarely ever happens. So FRAND in practice doesn't deliver on this promise. So in my presentation, I will be delving uh, into the aspects of just yeah in the aspects of the core question of my paper would be, do today's FRAND regimes ensure market fairness and equitable access? And I will be using a comparative analysis from the regions of EU, US, India, and China, moving on with a doctrinal review of certain policies that are available. Further, I will also be looking at the law and economics lens, and also looking at the outcome sought and the recommendations that are present. So, firstly, moving with the EU and just a moment, sir, just a moment. Yes, sir. So just moving on with the EU and the different comparative lens with different jurisdictions. Firstly, in the European Union, sir, the Huawei versus ZTE case created a negotiation roadmap. So, sir, so what I'm trying to look at here is the different approaches taken by different regions in this particular case. So, in the European Union, the lens set out in this particular case as a precedent was to have a negotiation roadmap. However, in the United States, it focuses on more of an economic and competitive law perspective. And but the Court of Appeals reversed this particular order, saying that it is just aggressive competition. So this entire anti-competitive aspect was negated in its entirety in the US. In India, however, we see the CCI investigated Ericsson in the CCI versus Ericsson case for charging royalties on the final phone price instead of just the chipset. In this, the local manufacturers such as Micromax and Intex also argued that this was indiscriminatory in nature. Here, competition law played an important role, and in jurisdiction with larger implementer bases such as India and developing nations, they prioritize affordability, sir. And this particular affordability might not be feasible for these kind of developing nations when we talk about certain SEP holders monopolizing the market. Now, to look at the economic perspective of the same, so there is a sort of royalty formation, sir. So there is a debate over royalty base, which is a clash between the device versus the smallest saleable unit. The question is whether we should charge royalty for, in a phone, for example, should we charge royalty for the entire phone in itself or a particular chipset? So this difference can massively affect the price. So, and also there is royalty stacking. When one device uses hundreds of SEPs, the combined royalty can become unaffordable. And finally, injunctions, sir. SEP holders often use the threat of injunctions, as we saw in the USA case, not just to protect their rights, but also to stop the other person from even utilizing this SEP in itself. So, sir, my research shows three major problems, sir. First, there is a transparency deficit. There is very little clarity on comparable
Miss
licenses or
Adora,
how
try to
royalties are.
conclude in 1 minute. Miss Adora, try
Yes,
to
sir.
conclude in 1 minute.
Yes, sir. Sure, sir. Oh, I'll just go ahead with my reform and agenda aspects, sir. So, what I look at in the perspective of what can we fix in this particular scenario. First is greater transparency within the standard setting boundaries, sir. So, to implement FRAND licensing in itself, there must be equitable and proper standard set in the SSOs and standard setting organizations, and also HCs and everything, sir. Further, moving on with respect to context sensitive royalty determination, sir. So every context must be looked at in order to set the royalties. And the third one being regional and global cooperation, sir. Considering the aspect of globalization in the current realm, we must look at the aspect of globalization into in order to incorporate this itself in our particular scenario, sir. So with this, I would like to end. I would be very glad to answer any questions if so, if you all have.
Yes, Ms. Adora, like what legal and policy mechanisms can make FRAND licensing more transparent and equitable, particularly addressing concerns of royalty stacking and discriminatory licensing in emerging technology market?
So, in this context, I personally feel that a more standardized method of setting certain, probably a policy framework within the SSOs would be a great mechanism to deal with it. Especially especially it should be in line with the global denominations, sir. So, if it's in line with what is happening globally, and in this aspect of globalization, I feel that would really help specifically developing nations like India, sir. So I feel like there must be a standardized method and with to even implement FRAND in itself. Here the question is the FRAND is not implemented in its totality, which is causing the problems in itself. So this is what I suggest, sir.
Okay, so now my suggestions specifically in line with your, as you mentioned, SSO. So in India, in other domains, we see the emerging domain of fintech, where the RBI is continuously regulating the financial technological aspect of the fintech market. In
Yes.
last year, we see SRO in fintech regulation. SRO is self-regulating organization. What are
Yes,
SRO
sir.
specifically? The people who are already expertise in holding the fintech market, like the big corporates, they are regulating themselves itself. They are nominating, they are appointing their own leaders, and they are working. So what is the
Yes.
major issue in the specialized field, specifically talking about the SCPs and the fintech or any other specialized domain? Yeah, the not in general everyone can come up with the regulators. So all the
Yes.
regulators cannot regulate it until and unless the regulator itself are having that expertise of hand holding or regulating those. So
Yes.
the
Yes.
suggestions in as per your paper, there you can also include one more thing: the SRO's assessment specifically. The
Yes. Sure.
SROs for the SCP segment in India,
Yes.
self-regulating organization is like working in various domain, Like
Yes.
from last year, it's also started working in fintech law. So why not
Yes.
in SEP? In SEP
Yes, sir.
also there are companies, so the self-regulating groups which can be formed, and they by themselves can regulate the SEP in SEP licensing domain in India, compiling with the
Yes.
FRAND and also making it more transparent. Because the self-regulating groups or the organizations are completely autonomous. They are having the accountability, not like it's not like a government setup where the people can just turn out like without having the accountability towards that group, which makes it more accountable, more transparent, and also more accessibility for the stakeholders to come up with all the grievance
Right.
redressal to the licensing methods. Understood?
Right. Yes, sir. Yes, sir. Yes.
Okay,
Thank you so
that's all.
much for your input, sir. Thank you.
Yes. Now we'll be calling Simran Gupta. Simran Gupta, are you present? Yes.
Uh, so,
Simran Gupta.
yes, sir. Am I visible?
Yes, you are visible and audible. You can share your presentation.
Okay. So it will just take me 2 minutes. I'm just uploading the presentation. Uh, so is it visible? Hello.
Simran, it's not visible yet.
Ma'am, it is taking this 2 minutes. I guess it is uploading.
Miss Simran, please be fast.
Sir, it is uploading. It is taking a bit time. I don't know why. It is processing. The PPT is processing.
Okay, you can start your presentation. When it will be loaded, it will be reflected.
Sir,
Yeah,
is it visible?
yeah, it's visible.
Okay. Good afternoon, everyone. Today, I, Simran Gupta, and my co-author Anjali will be presenting on our topic is SEP licensing in the automotive industry. Our discussion will highlight the complexities of standard essential patents and competitions law, the part towards global harmonization. Moving towards the next slide. The automotive industry is no longer just about engines and mechanics. It is now a data driven ecosystem powered by 5G, vehicle to everything communication, and autonomous systems. These advances make SEP crucial. However, unlike telecom, the automotive sector has a multi tiered supply chain involving chip makers, module suppliers, and OEMs, which complicates licensing responsibilities under FRAND terms. Understanding SEP in crux, I would say a standard ensures compatibility across technologies. A standard essential patent is a patent necessary to implement that standard, meaning you can't avoid it if you adopt the standard. SEPs are vital for connectivity like 4G, S5G, and Bluetooth, and royalties are paid to SEP holders. This makes SEP management central to innovation and adoption. Moving toward the next slide, the FRAND licensing, that is fair, reasonable, and non-discriminatory. To address fairness, we use FRAND licensing. Fair means equitable terms, reasonable ensures royalty rates are not excessive, non-discriminatory ensures equal access to all. The FRAND principles are essential to balance the interest of innovators and implementers. The competition laws and SCPs are used because SEPs can create monopoly like power. Competition laws treat them as essential facilities. Without FRAND compliance, SEP holders could impose unfair terms of refuse licenses. Thus, competition laws ensure technology remain accessible and market remain fair. Automotive SEP licensing landscape, unlike telecom, where licensing happens at the device level, the automotive sector faces disputes on whether royalties should be paid by component suppliers or at the vehicle level. SEP holders often push royalties based on car values, raising issues of overcompensation. There is a key case named Nokia versus Daimler illustrated these tensions but was settled without a clear ruling. I would ask if my co-author could proceed, sir.
Yes.
So now let's look at some national policies, SEP policies. In US, in April 2023, the European Union proposed SEP licensing reforms for transparency and FRAND clarity, but withdrew them over royalty setting concerns. SEP governance remains under Article 101 and 102 of TFEU. An ETSI policy which mandate FRAND but omit rate rules. A revised plan with a SEP register, mediation, and global harmonization is advised. Now, under US, the US handles SEP licensing via patent law, antitrust, and court rulings with no unified framework. Proposed laws like ZERA face criticism, and DOJ policy withdrawal in 2022 created uncertainty. Experts call for clear guidance, fair valuation, ADR, and SME support. Now, looking at the India's regulation of SEP licensing, India regulates SEP through the Patents Act 1970, Competition Act 2002 without a dedicated law. While the Patents Act enforces FRAND and allows compulsory licensing, the 2023 Delhi High Court ruling limited CCI's role in royalty disputes, creating uncertainty. A unified framework with clear FRAND rules, a public SEP database, transparent royalties, and global standard setting participation is essential for clarity and fairness. SEP licensing varies globally. The comparative approach is thus EU uses a competitive driven approach under TFEU and CJEU rulings with no statutory FRAND regime. US treats FRAND as a contract issue, limits antitrust intervention, and favors litigation, leading to forum shopping. India balances patent and competition law, prioritizing affordability, but faces CCI court jurisdiction conflicts. These differences, EU's focus on competition, EU's patent-centric model, and India's accessibility-driven approach complicate global harmonization. A unified framework, international cooperation, and clear FRAND principles are essential for a fair, predictable SEP licensing system that promotes innovation and affordability. Now, many challenges persist in the realm of SEP licensing, including but not limited to fragmented legal frameworks, absence of uniform FRAND terms and valuation, divergent policy priorities, forum shopping, judicial uncertainty, and high compliance costs. Therefore, achieving global harmonization in SEP licensing demands international collaboration, unified frameworks, transparency in valuation, and judicial clarity to balance innovation, incentives with affordable access, and a fair, predictable, and
Team,
competitive.
move ahead to the conclusions and suggestions.
Sir, yeah, it's completed. Thank you.
Okay. So specifically, when you had mentioned regarding the global harmonization, what are the policies for SAP we have to look into consideration?
Sorry, sir.
When we look into the global harmonization, as you provided, that there should be a transparency and global harmonization. What are the policies we should look into consideration?
So, policies like there should be a uniform approach to SEP licensing. The FRAND rates are, for example, there is no codified some FRAND rates. It all depends on the manufacturer. Then we can implement role-based access in SAP to maintain data integrity, and data privacy should also be maintained. Yes, sir.
Okay. So, like for your paper specifically, 3 points should be emphasized in a very rapid, detailed manner. Specifically, first point being the international harmonization standard. What are the West and East, like all the European countries, along with right now the ACP working is majorly done in the Asian subcontinents, the Indian subcontinents in these particular zones. So what you have to do, you have to look into the various offices, IP offices, intellectual property offices, what they publishes their report. You can look into consideration IP office Australia, IP office China, IP office UK, US, and also the IP of office of Italy, Japan. These offices, they subsequently publishes the report on the SCP global harmonization and what are the policy setback those reports are having, and then you can include it in your study specifically for the publication. Understood?
Okay, sir. Thank you, sir.
Yes. All right. Thank you.
Thank you, sir.
Now we will move ahead to the next participant, Aditi Solanki.
Yes, sir. Am I audible?
Yes, you are audible. Be little louder.
Yes, sir. Am I audible now?
Yes.
Yes, sir. Good morning, sir, and good morning, everyone. I am Aditi Solanki, and this is my co-presenter, Kushal Pathak. And it is an honor for us to present our work on examining the role of UNCTAD in aligning global competition law approaches to standard essential patents in this esteemed conference. So we began this research by looking at how globalization has changed the way we think about standard essential patents. They were once seen as technical legal tools, and they now sit at the very crucial juncture in the center of uh, uh, this connected world. But still, there are various conflicts about licensing, fairness, and about how law should respond when private innovation meets public need. In most of the developed economies, strong regulatory systems have emerged to tackle these questions. For example, Europe uses its competition law, particularly Article 102 of the Treaty on Functioning of the European Union. The United States has relied on antitrust litigations, and China, through its anti-monopoly law, has begun addressing these issues like excessive pricing, the discriminatory licensing, etc. However, these developed jurisdictions not only have the rules but also the institutional confidence to enforce them. However, when we come to the global south or the developing countries, for example, in cases such as Micromax and Intex versus Ericsson, the to balance the power of multinational patent holders with the survival of domestic manufacturers. Similarly, these are the challenges that are also evident in Brazil and South Africa, where regulators often lack the resources to engage deeply with technical licensing disputes. And also in countries like Nigeria, the institutional framework is still too thin to meaningfully address these issues at all. So all this creates a very striking asymmetry between the developed and the developing countries. Developed economies effectively define what is meant by fairness or reasonableness in the SEP licensing framework. This not only puts the firms in developing countries at a disadvantage, but it also means that their voices are often missing from the global conversation on how SEPs should be governed. So now I would like to invite my co-author, Mr. Kushal Pathak, for explaining the role of UNCTAD in this field and how it can address this concern that prevails in the developing countries.
Thank you, Aditi. Good afternoon, everyone. As we have seen the regulatory asymmetry in the legal aspects, as discussed by Aditi Solanki, uh, related to the standard essential patents, this is where we believe that UNCTAD plays a central role. Unlike WIPO, which often reflects the interests of patent holding states, or the WTO, which is shaped by tough negotiations, UNCTAD carries a development first mandate. It can look at standardization patents not just as a matter of legal doctrine, but as a question of fairness, access, and sustainable growth. We argue that UNCTAD could step in the issue with concrete measures. One possibility is to prepare model guidelines on SEP licensing that seek and speak directly to the needs of developing countries. These would help judges and regulators interpret FRAND commitments in a way that makes sense for their domestic markets. Another step could be organization of regional roundtables, where regulators in Africa, Asia, and Latin America can learn from each other's experiences. UNCTAD has already run successful peer reviews in competition law, and there's no reason that model cannot be extended to standard essential patents. Transparency is another pressing concern in SEP licensing. At present, SEP licensing is often shrouded in secrecy. Smaller firms, especially in developing countries, face significant information gaps when negotiating with global SEP holders. Here, a public SEP database under UNCTAD could make a real difference, providing clarity on ownership of various SEPs and the terms under which it exists. It could also encourage licensing practices that serve the wider public interest rather than only the strongest players. Thus, the future developments in SEP depend on a collective action. Regional alliances like BRICS and the African Union and ASEAN are already beginning to think about shared approaches to digital governance. UNCTAD can act as a bridge, helping these groups coordinate and promoting soft harmonization through guidelines and expert dialogues. Our conclusion is not that UNCTAD should replace existing bodies, but that it can fill the critical gaps. It can give developing countries both a voice and a platform in shaping how SCPs are regulated worldwide. In doing so, it can help build a global framework that not only rewards innovation, but also ensures access, fairness, and shared growth. I would like to thank everyone who made this possible for us to present this in this conference.
Okay, team, I have one question for you. Specifically, when you mentioned UNCTAD serves as an effective platform for harmonizing divergent national competition law approaches for the SCP licenses, like to what extent, according to you, it gives a mandate and limitation compared to the organizations like WIPO and WTO?
Kushal, would you like to go ahead with the answer or?
No, you can go ahead. No problem.
Okay, thank you so much. Thank you for the question, sir. So this is the very basis of our paper. Since we know that WTO is a treaty-driven and rigid form of body, and on the other hand, WIPO, it tends to prioritize patent protection over anything. Neither of them offer the development-sensitive tools that the countries in the global south urgently need. On this aspect, UNCTAD it differs from these two. It runs voluntary peer reviews of national competition regimes. It offers tailored technical assistance for judges and regulators, and it convenes inclusive expert platforms where developing countries uh, they actually shape the agenda. It also issues soft law guidelines and model rules that evolve quickly without binding pressure. So these tools that differ from WTO, WIPO, they make UNCT uniquely positioned to help countries uh, to navigate SAP licensing, building capacity, fostering consensus, and ensuring that innovation and access they are balanced in practice and not just
Till now, United Nations Trade and Development has done any sort of initiative for SCP licenses or licensing protocols.
so not particularly that we have come across in the research.
Okay, so major lacuna what I find in your paper specifically when you make a comparison between a WIPO and UNCTAD model, like both are having various different objectives. WIPO
Yes,
is
sir.
only set up for the intellectual property, all the IP governance, and providing the standard mechanism how to run and how to come up with the IP policy. That's only the duty of WIPO. Now, when we talk about the UNCTAD, it's for the development of the trade policy, and the development of the nations within the aspects of trade. So now you have to come up with the assessment. Since you guys are making a comparison between a WIPO and the UNCTAD, you have to come up with like whether UNCTAD is eligible for coming up with the policies of the SAPs or the like for the IPR, because already there is a segmentized, like in Indian construct, we see in Indian constitution also there is a separation of power. No other organism no other organization is having that scope and scope of working beyond their power which has been allotted to them. So in a similar way, the organizations in the United Nations are having their limitation and scopes. So in that, UNCTAD is limited towards only in like a trade and development of the trade, and the WIPO is provided with the like sole interest and limitation of working in intellectual property. So I'm not hindering that your your research, whatever you have done up for the recommendation purpose, that's completely fine. But my point is, what are the evidences or what are the concrete proofs you had provided for coming up with the this solution that UNCTAD can serve as the most effective platform? You're getting me? So these are the things which you have to incorporate in the paper so that it can come up, because when you are countering it, at that time the burden of proofs lies in with you. So you have to provide the proofs that how you are eligible, like how UNCTAD is eligible more than the WIPO.
Sure, sir. We'll research further on that and add that aspect into our paper. Thank you so much for that recommendation.
Thank you,
Okay,
sir.
all right. Now we will move ahead with the next participant, Yashvi from Shrestha School of Law, Chennai. Yashvi, yes,
Am I audible, sir?
yes, you are audible.
Sir, they didn't add my co-author, sir. Dhruvi Jain.
Okay, yes, your co-author is also added.
Okay, she'll be starting the presentation, sir.
She is added, but I don't think she is having a good network connectivity.
Hello, sir. Am I audible?
You are audible, but you are not visible, Miss Dhruvi.
Um, I'm going to present the screen, sir.
Your screen is also not visible.
Sir, is it visible now?
No, it's not.
Yes, sir. I have made it possible, so it's visible now.
Yes, it's visible now.
Okay, sir. Can I start, sir?
Yes, start.
So, good afternoon. Myself Dhruvi from Savita School of Law. So, today we are presenting a paper on a study on access to SEPs in medical sector, challenges in low-income economies with special reference to AI. So let's begin with a real life example. So imagine a rural hospital in a low income country where doctors want to use an AI diagnosis tool, but the cost of accessing the technology is too high due to patent restriction. So what will happen to the patient in such a setting? So this grabs attention and it is directly linked to our topic. So, introduction. In today's world, the medical field is rapidly changing with the help of new technologies like AI. So, AI is being used for many purposes, such as, for example, diagnosis of diseases, treatment planning, or patients monitoring, and even robotic surgeries. So, these technologies rely on a certain technical standards that ensures devices and systems work properly together. So these standards are protected by SEPs, that is standard essential patents. So SEP are special patents that must be used if someone wants to make a product that follows a technical standard. If we see, for example, Bluetooth, Wi-Fi, or 5G in a medical devices. So this becomes a challenge because most of the big companies that own these patents often charge a very high fees for their use. But if we see for low-income countries, this becomes a very serious problem. Hospitals and healthcare providers may not be able to afford afford these expensive license, which means that they cannot use this AI based medical technologies. As a result, the rich countries get the benefits of the most of the advanced healthcare, while the poor countries are left behind, which increase the global health inequality. So, if we see in developed countries, the companies pay licensing fees to use SEPs, but the costs are often covered through insurance or government support. But if we see in a low income economy, hospitals and health providers often do not have the resource to afford such licenses, and they don't even have strong legal terms to negotiate with patent holders, and they even lack awareness how to obtain these rights. So the issue is further complicated by FRAND, that is fair, reasonable and non-discriminatory licensing, which is supposed to ensure fair access but lacks transparency.
Miss Dhruvi, your slides are not moving.
Yes, sir. So the objectives are to examine the role of SCPs in AI-based medical technologies, to
You can
identify.
move, Miss Dhruvi, you can move to the challenges and the suggestions, specifically solutions.
Sir, we have analysis, so my co-presenter will be presenting that.
Okay.
So first figure, which is figure 3, it shows the relationship between age, and the question here asked was, what is the biggest obstacle in accessing AI medical tools? So most of the respondents chose high cost or patent restriction as the biggest barrier, because affordability is the most immediate problem in low income settings. Moving on to figure 5, the relationship showed here was age, and the question asked to the respondents was, does patent rule affect cost of AI based medical technologies? So the most of the respondents agreed that patent rule significantly increases cost, because SEPs means company must pay licensing fees, which makes AI driven medical tools unaffordable in developing countries. Next, moving on to figure 7, it shows the relationship between gender and obstacle for low income countries in accessing AI medical technologies. So respondents largely chose high licensing tools or lack of affordability, because SEPs and patent monopolies prevent low income countries from adopting cutting edge AI medical system. Now moving on to figure 6, gender, the relationship showed here was gender and the main use of AI in medical field. So the highest option the respondents choose was diagnosis and treatment support option, since this is the most visible and impactful way AI is currently used in hospital for disease detection, imaging, and predictive outcomes. Also, people see and experience this benefit directly, so they perceive it as the main purpose. Now, the main findings from this graphs and studies are, SCPs and strict patent rules makes AI-based medical technology more expensive and less available, particularly no income areas. Since and also a lack of information and awareness about this AI-driven tools, and also is a key barrier, and also cost and awareness, and also lack of trust in technology and limited adoption by hospitals are significant hurdles. Now, moving on to suggestions. So, first suggestion would be to establish transparent and user-friendly rules about SCP's licensing cost. Next, to introduce pricing models with lower fees for lower-income countries. Next, to encourage development and use of non-patented AI tools for public healthcare. And lastly, to support multi-country initiatives balancing innovation and reward with broad, fair access to AI-powered healthcare. Now, over 5 billion people, moving on to conclusion, over 5 billion people worldwide still lack access to safe, affordable healthcare, with low and middle income countries facing the greatest needs and encountering major SCP and infrastructure barriers to AI adoption. And also in the year 2025, numerous new AI healthcare patents have been granted. For example, federated learning for clinical trials, AI for diagnosis, but commercial deployment is largely limited to wealthy markets. So, uh, high cost, low awareness, and weak legal system lock out poorer countries from AI driven health innovation. And also, intellectual property protection must be reconciled with the urgent need for universal access to medical technology. So, in summary, SEPs play a crucial role in advancing medical AI, but their inaccessibility in low income economies creates a significant healthcare dividing balance innovation incentive with public health need is essential. If equitable framework for SCP access are implemented, AI can truly become a global tool for saving lives, not only a privilege for wealthy nation. So, access to medical technology should not be defined by the wealth of a nation, but by the urgency of human need. Thank you.
So, like team, I have one question. Specifically, in the last concluding line, you had mentioned that the access should be equitable in even in the low income group. So, when we talk about the accessibility, so there are two things which always comes into question: the accessibility, whether that accessibility is a privilege or the necessity. So when we talk
Sir,
about
I
the
think
AI, yes,
I think accessibility is a necessity, sir, because uh, medicine is a very basic need, like how we survive on water or something like that. And also in cases of emergency, it's a very basic need. So I think it's a necessity more than a
it's
privilege.
not medicine. Like you had mentioned, AI driven medical technologies. So
Yes,
whether
sir.
AI driven medical technology falls under the necessity segment or it falls under the privilege segment, because there are working professionals, there are people who are already providing a very low cost effective medical solutions for the people. So whether AI driven
Yes.
medical technology is a privilege or it's a like a necessity, you have to first assess this in your paper. Then the
Yes.
second thing, when you talk about the surveys done, the surveys are the primary sources of the report, that's completely fine. But what are the international frameworks or the FRAND commitments which your paper has addressed while addressing these barriers?
Hmm. Sir, Patent Act, firstly, the Patent Act of 1970, and also WHO FDA collaboration, sir, and also the WHO World Health Organization, and also, yeah, that's it, sir. That's all we saw.
Okay. So, like, take these two suggestions. First, the assessment has to be made on the AI-driven medical technologies on the basis of their whether they are the necessity or whether privilege. If privilege, then the complete friend commitments is not applicable on that. If it is necessity, the technology is so vital that everyone should have it, then the friend commitments, that the fair and reasonable and the equitable access, then we can say that yeah, it is also possible for making a policy for the friend commitments can be done in all those AI driven technologies. Now third thing, so you will assess your paper on the flexibility and friend commitments, trips, adaptability, how these thing are addressing these barriers. So this thing has to be like properly added into the paper and thoroughly has to be done. Understood?
Yes, sir.
All right, that's my suggestion.
Thank you, sir.
Thank you, sir.
Now we will be moving ahead with the next participant, Sakti Priya B. Yes, Miss Shakti Priya. You are not audible.
My co-author has not an answer.
Yes, you are audible.
Shalia.
Okay, Miss Shalia, you are also not audible. Kindly unmute yourself. Miss Shalia, kindly speak. You are not audible. Unmute yourself and speak. Your mic is muted. Kindly unmute yourself and speak. Miss Shalia, your mic is muted. Kindly unmute yourself and speak. Miss Shakti Priya, your co-author has left the session.
Okay. Just 2 minutes, I'll ask her to answer.
Yes.
Hello.
Yes, you are audible now.
Sir, am I
You can.
audible?
Yes, you are audible.
Yes, sir.
Yes, you can present your screen.
Okay, sir. So I'm the co-author. My name is Shalia, and we are grateful to present our presentation. Our presentation is titled on the front licensing and the market fairness. So, sir, can we start?
Yes, you can start the presentation.
Shakti Priya, can you present the PPT?
Yes, PPT is visible. You can start.
Yes, sir. First, we can start with the introduction. Think about the video call you joined this afternoon or the streaming app that you're scrolling as a daily routine. All of them depend on the global technical standards. The global technical standards are considered as the standard essential patents. So these are the standard essential patents must be licensed under the FRAND. FRAND licensing is comprised with the fair, reasonable, and the non-discriminatory uh, elements. So the FRAND is designed to balance the patent protection with the open access. But in practice, the disputes over the royalties, contracts, and the court strategies show how fragile that balance really is. Our paper is mostly concerned with the issues. Our issue is mostly concentrated on how should the owners of these critical technologies can be compensated, and how should these patents be licensed fairly to ensure the accessibility and prevent the misuse of the market fairness. And the next part will be discussed by our author, Shakti Priya.
So the second one is the analysis of FRAND, equity and digital inclusions. In reality, FRAND often fails, like patent holders may demand excessive royalties or insist firm licenses entire patent portfolios or blocking smaller innovators. The equity issues like mainly the royalties are usually calculated on whole, like a whole device, not on a single patented compound. And the NDA, like the non-disclosure agreements, hides the true terms. Then the digital divide in the sense, so instead of bridging the digital divide, the cost of licensing slowly adoption in low income rates, it practices often widen it, and it's delaying the rural broadband in example mostly in rural land in Asia and Latin America.
So in the next part will be the literature review on the FRAND and the SEPs. So the standard setting organizations require the FRAND to keep the patents broadly accessible. From the competition law perspective, the FRAND licensing helps to prevent the abuses such as patent holdup and the royalty stacking. But what counts as a fair and reasonable reasonable market? There is no correct definition in the worldwide level for the fair and the reasonable market fairness. So courts disagree across the jurisdiction, creating the global uncertainty. And today, France's reach is extending beyond the telecom into the digital platforms and the data governance, raising the fresh regulatory questions. And the
Then the
next will be
comparative study of FRAND licensing. The comparative study of FRAND licensing. In European Union, the landmark cases like Y versus ZTE case created a clear obligations of SEP holders must act fairly with royalties tied to the market value. Like India, however, still evolving, not like European Union. In the case of Ericsson versus Micromax, interim royalties were ordered, but India lacks essentiality and checks the royalty benchmarks. Then the lesson the mainly we have to understand is India urgently needs a standard or structured FRAND framework aligned with the global best practices.
Next, we are mostly concentrate with the competition law. In India, the Competition Act 2002 is playing the central key. Based on the Competition Act, Section 3 prohibits the anti-competitive agreements, and Section 4 stops abuse of dominance. Section 27 empowers the CCI, Competition Commission of India, to impose the remedies and uh, ensure the penalties uh, for those who violate the FRAND licensing, but overlaps with the patent law trigger the jurisdictional conflicts. A serious issue is royalty stacking, costs multiply across the patents, pricing out the smaller investors. So the next will be discussed by the Shaktipriya.
Then the possible reforms or a policy needed is a public disclosure, SCP disclosure, and there is also a FRAND guidelines and even a compulsory licensing to protect fair access. Like
Team
then
move ahead
there is
to
a
the
FRAND.
move ahead to the solutions. Team move ahead to the solutions and recommendation.
Yes, sir, that's a role of international. Shalia will say it.
So to avoid these legal wars, the arbitration and the mediation are emerging as the better tools. They offer the faster and the confidential cross-border solution, but both sides must act in good faith. SCP holders must disclose the patents and negotiate transparently. Implementers must also negotiate sincerely while retaining the right to challenge the unfair demands. So the broader goal is clear: the create cooperation framework that balance exclusivity with accessibility, especially vital for the developing markets.
To conclude with that, FRAND was meant to balance the patent rights with public access, but today uncertain definitions and excessive royalties often undetermine or undermine their promise. Like, what are the solutions? What are the come up with? We have to do is it's first it's patent pooling that can ease our burdens and the compulsory mediation and the anonymous royalty disclosures. Then regulators like the European Union have acted against the abuses, but SMEs remains vulnerable. Like public licensing platforms and legal aid mechanisms could help the level playing field. Then the bigger question is not whether the FRAND survives, but how we redesign it. The future depends on the policy clarity and global coordination and striking a true balance between the innovation and inclusion. Thank you, sir.
Thank you, sir.
Okay. So team, how can friend licensing framework be be ensured to be preventing discriminatory and exclusionary practice from the large corporates? Like what according to you the friend licensing framework is providing fairness in the market?
Then,
Yes.
so once again.
Like my question is how according to you to what extent the friend licensing framework can ensure fairness in the market?
So the public SCP disclosure is mandatory to fairness, sir. Am I
Okay.
audible?
Like it
Yes, you are audible.
So, the FRAND licensing ensures a fairness in the market by keeping the standards open. Like when the patent is essential for global standards, like giving a 4G, 4G or a Wi-Fi or Bluetooth, like this prevents a single company from blocking access to their standards, and it also promotes fair competition, and it also preventing abuses like stopping the patent holder from their position after it is adopted, and it also limits the royalty stacking and by overlapping the royalties and their cost, and it also encourages the innovation and access by like companies can safely invest their devices or services knowing that they can access necessary technology, like consumers benefit from cheaper interoperable products like mainly it ensure the fairness by balancing a patent owners with rights from the need to open access to the essential technologies.
Okay. All right. My suggestions would be you should assess the friend licensings and the market practices specifically on the line of market economics. You should come up with the small enterprises assessment ki how friend licensings can impact the small enterprises and whether the fairness or the equitable licensing terms are provided through the friend licensing to the small businesses or the small SAP holders. So that's how your paper should add it, and the assessment should be made accordingly.
Okay, so thank you, sir. Thank you for your suggestion, sir.
Okay, all right. Thank you.
Thank you.
Now we'll be moving ahead with the next participants. Joshua Joseph.
Yes, I'm audible.
Yes, you are audible, man. And Arya Bhaskar.
Yes, she's my co-author. Just presenting the screen.
Okay.
Is the screen visible?
Yeah, the screen is visible. You can start your presentation.
Right. Thank you so much. So, good afternoon, everybody. My name is Joshua Joseph, and I, along with my co-author Arya Bhaskar, have written a paper called "Exclusive Patents Excluding Patients: SEPs, FRAND, and IOMT." So basically, recently we have been seeing a lot of an increase in wearable technology regarding that's giving access to healthcare and everything, and all of these wearable technologies, they are actually based on SEPs. As the previous presentation we've seen so far, how essential it is for the interoperability and connectivity. So one of the main thing that we look into is the FRAND licensing and how India is maybe impacted because of its over reliance on SAPs from foreign SAPs especially. So the paper structure that we have from the paper structure itself, we have an overview of SAPs, FRAND, and IOMT, a comparative jurisdiction overview of India, US, and EU.
Mr.
The
Joseph,
impact.
you can straightly go to the research questions and the problems and then solutions.
Yes, yes. So the thing is, my co-author is going to describe what IOMT is more in detail so that it can be understandable for the audience. So yeah, I think please.
So, standard essential patents are patents that cover technology essential to comply with technical standards. These standards are set by recognized bodies such as standard setting organization. In healthcare, this plays out in the Internet of Medical Things, that is IOMT, which means medical devices and applications that are connected to the internet and share data in real time. Examples are wearable heart monitors, connected insulin pumps, and smart hospital beds. To check the abuse of monopoly power, SEP holders are bound by the FRAND terms. In healthcare, patents shape access to life saving technology, and restrictive SEP licensing and FRAND terms raises costs, stall innovation, and hits rural India hardest, making a health specific legal framework urgent.
Thank you, Arya. So I know this has been already discussed in the previous other presentations. Indian jurisprudence, Ericsson versus Micromax regarding royalty disputes, CCI versus Bharati, as previously mentioned already, how the court stated that the CCI can only look into competitive aspects of any case, and also regarding this has already been discussed that there's no FRAND methodology as of now, and there's also patent hold up and hold out. Recently, there was a case on Lava versus there was a case on by Lava wherein it was said that they have to put in a security deposit. So again, the Indian jurisprudence regarding SEPs is currently evolving itself. So, and again, when we look at a comparative perspective of course, Huawei versus CTE was already discussed, in which SEP holder had to notify the infringer, make a written FRAND offer, allow a counter offer by the implementer. Failure to follow up would be equal to an abuse of dominance under Article 102 of the TFEU. And regarding United States itself, FRAND obligations, Microsoft, Motorola, all of this has technically been discussed, so I will not be going over through it. But when we look at how it has impacted the IONP, so when we look at economic barriers, so as stated, like royalty stacking itself is an issue where basically an item itself, the price increases because of the amount of SCPs licensed needed for it. And due to these higher costs, it eventually lead to affecting the public, because higher costs like these insulin pumps itself, it's very much needed because currently our aging population and our many people are getting allergies or having health complications, right? And so with these higher prices, nobody will have access to these particular life-saving machinery or technology itself. So also, as I previously mentioned in the abstract itself, India widely depends on foreign SEP holders instead of trying to look into its own, creating its own technology in India itself. So, yeah, when we look at the comparative lessons, EU has a great, outlook into it. It has a negotiation protocol like how we saw. It first, you have to, inform the infringer, and then after that, you negotiate itself. And then SEP registration and transparency and royalty rates. While in the US, we see another injunction is rare after that. After the injunction is rare after the eBay case, basically. Yeah. So SSBU keeps a royalties approach basically instead of the pricing based on the whole component. The whole machinery itself. It's based on that small component, right? So we would be going on to the recommendations of the. So Arya, can you take?
Yeah. George, can you do full screen so that people can read the recommendation?
Is it now?
Yeah. Yeah.
Yeah.
Coming on to the recommendation, India needs clear health-specific reforms to ensure innovation serves patient and not just profits. So coming on to the first recommendation, there should be a sector-specific rules for SEPs in healthcare. Medical devices should be treated as public goods with option for compulsory licenses in health emergencies and royalty caps to stop inflated costs. Secondly, FRAND licensing must be transparent. A national registry should require SEP holders to publicly disclose rates and terms, share licensing arrangements to relevant third parties, and publish impact statements on access in low income areas with proper oversight. Thirdly, there should be patent pool, differential royalties, targeted subsidies, and open source IOMT to reduce dependence on foreign SCPs. With these steps, India can drive innovation while keeping healthcare affordable and accessible. Now, coming on to the conclusion, next slide. Exclusive patents should never mean excluding patients, meaning that innovation cannot come at the cost of access. Yes, a patent should sorry yes a patent should reward the creator, but it should also serve the larger goal of making healthcare affordable and accessible. Because at the end of the day, what good is innovation if the very people it was designed to help are left behind? Thank you.
Okay, so team, the similar topics has been already discussed in the previous presentations in regarding healthcare sector. So there also I asked one question specifically when we talk about the healthcare, the AI driven healthcare. So there has to be like the FRAND licensing is very subject matter of commonly used technology. When the technology is a privilege, their FRAND licensing is not completely applicable per se for the fair and reasonable ground, because the privilege itself has a cost. So there you cannot term it that the technology has to be fair and the reasonably has to be the cost catering. So you cannot term it up, because who has developed that particular standard essential patent or the patent holder, they have developed it for basically the profit making and for making the adequate return of the investors. So that's the only motive of developing a new innovation. But when we talk about the medical, in terms of medical technology, like if a AI is getting developed, or that treatment is done by AI, the same treatment which was done for years by the human doctor, or the other humanly made things, so whether that technology is eligible for calling it as a necessity or it's a privilege, is my first question to you guys. And the second, if it is doesn't falls under the necessity segment, then how FRAND licensing terms would be applicable upon it?
Should I take the first question, Joshua? Okay,
Yes.
so sorry. Uh, Uh, so, sir, our motive of writing this paper was that to see IOMT, especially not basically AI medical healthcare, but IOMT as a necessity. Because we can see in COVID as well, they were contact, contactless monitoring, making it sure that the doctor and the patients are in the contact to be very less. So, in this, SAP came into being, and hence we can see that this can be a necessity. Various examples, such as I've given example, like cardiac implants, telemedicine devices, glucose monitoring, these are all to be seen as a necessity. Given to be seen IOMT as a privilege, we can see the Apple Watch, the Fitbits, maybe not affordable to a lot of people, only can be seen as a luxury, but these are also to be seen as privilege. IOMT to be seen as a privilege, but also necessity when it comes to glucose monitoring, insulin monitoring, and etc. So it can be seen as a privilege plus a necessity based on what examples we are giving.
Okay, so like when it comes under both the segment, now you have to specify in your paper. That's what my suggestion will goes now. Like the specification has to be made in your paper. Like in what segment the IOMT can come under the privilege, and also in what segment it can come under the necessity. So if it is coming under the necessary segment, then only the FRAND licensings can cater upon the fairness and reasonable ground. Otherwise, FRAND doesn't cater the privilege segment, because there, when the person is more concerned, if it is a privilege, then the people are ready to purchase it in any cost. There, it doesn't need to be a reasonable. It doesn't need to be a fair. It only has to be a appropriate like program what the people are ready to purchase. Understood? So that's how the major difference should be incorporated in the paper and thoroughly looked into.
Yes, sir. Thank you, sir.
Okay,
Thank
thank
you.
you. Now we'll be moving ahead with the next participant, Mr. Dinesh PK.
Sir, am I audible, sir?
You are audible, but you are not visible. Turn on your camera.
Yes. Sir, am I visible?
Yes, you are visible. You can present your presentation.
Yes. Sir, the PPT file is uploading. Sir, shall I start with the presentation when the PPT is uploaded?
Yes, you can start. In the meantime, it will be uploaded.
Yes. Good afternoon, everyone. I'm Dinesh VK from School of Excellence in Law. And my research particularly focuses on South Asia, where the FRAND licensing and competition law, we know about the current situation. So my research problem is basically fully covers on the SCPs, where there is an increasing access to the vital 5G and AI technologies, which are crucial for telecommunications and emerging digital economics. Um Globally, disputes over FRAND licensing and the requirement to the licensing patents on the fair, reasonable, and non-discriminatory terms are still being what to say, like defined very. The meaning for those terms in our Indian legislative are like no with no clear and clear cut definitions. So there are still legal disputes which doesn't define the terms fair, reasonable, and non-discriminatory. In South Asia, there are like 1.2 billion telecom subscribers still now, and we know about the emerging AI market here. The key questions include how do play in ACP licensing, and how can South Asian countries harmonize their approaches. My research significantly focuses on a first comprehensive analysis of South Asian ACP landscape and policy implications for 5G deployment and AI adoption, and the framework for regional cooperation. To start with, the standard essential patents are patents that claim inventions essential for compliance with technical standards. There are over like 50% of the TP holders include as more than 2 lakh declared 5G SCPs worldwide. The impact areas include telecommunication infrastructure, consumer electronics, which may include the recent developments in the 5G technologies and the cellular iPhones, and also in the automotive, like we know the recent trend in Tesla and etc., and also in healthcare IoT devices, and in the industrial automation. So the FRAND principles, as we know, fair, reasonable, and non-discriminatory, as used in the US legislation. Fair means equitable terms considering the market conditions. Reasonable, which refers to the proportionate royalties reflecting patent value. And non-discriminatory, which is not somewhat defined in our Indian legal context. The legal framework, as we know, the contractual obligations of SSOs, the standard setting organizations, and judicial enforcement to the courts, and the competition law oversight against some of the IP legislations, which are still to be noted. The key challenges include royalty rate determination. The royalty rate determination, which is like in the US, it's determined by the FRAND principles, is still to be defined under the Indian legislation. And we know about the patent hold up and hold out situations too happening in India. The recent cases include the timeline of the major cases include like the 2011, it was the first ACP case, like where there is a dispute between Ericsson and King Tech. And 2018, the Philips versus Rajesh Bansal case, where the post-trial victory was noted. And to skip to the 2024, the latest Ericsson versus Lava case, which was like uh, decided by the Delhi Court after like 11 to 13 years of litigation, and 244 crore damages were given. The judicial principles established include good faith negotiation requirement, willing versus unwilling licensee test. In my research, I have given a more wide perspective of this and portfolio licensing acceptance and device level royalty based preferences, which include the 5G technologies, which are now being synthesized with the other technologies, which may include uh, the there are like still there's a they still depend on the relevant market basis, which is somewhat
Mr.
not.
Dinesh, move to the conclusion and suggestions.
Yes, sir. Uh, yes, sir. Like for the policy recommendations, I would recommend like specialized IP tribunals. Like we have specialized tribunals for environmental issues and etc. Because as we are in the technology era, I would recommend a specialized IP tribunals. Also, judicial training on FRAND economics. Like it is somewhat like more important in our situation, and enhanced patent examinations for SCPs. Like they may misuse the abuse amount of dominant power which is given to them. And regional cooperation, like the organizations such as SARC, even WIPO has done some research to collaborate with the other organizations, and bilateral patent sharing agreements may be done. Also, joint competition authority coordination, such as the antitrust legislations and the Indian competition law legislations, may be harmonized, and the priority may given to common FRAND determination methodologies, which are not defined, and also the standardization of good faith negotiation procedures also can be done to make the ACPs more relevant to the patent registrations. And my key findings include that ACP, like the judicial approaches towards the ACP in the Indian framework, like we know Justice Pradeepa Singh and other justice have given a major contribution towards the ACPs in Indian legislation, and 5G and AI expansion can be done with new licensing frameworks. Uh, Further, for the future research problems, we can do some AI specific SCP frameworks and cross border enforcement mechanism. Thank you, sir.
Okay, Mr. Dinesh, I have one question for you. Specifically, you had mentioned the major connectivity between the SAP in the South Asian region. So,
Yes, sir.
what do you think the major issue in the South Asian region, specifically on competition and catering the FRAND licensing? What we see are the major challenges of the competition law. When we give the FRAND terms in a upper hand position, it violates the competition law. But when we stringent the competition law, it violates the FRAND. So, how to balance up these two kind of situation in respect with the SAP licensing policy in South Asia? What is your take on it?
Like, sir, the according to my research, the major problem would be the ambiguous terms. Like, we know that there is no clear-cut definition for fair, reasonable, and non-discriminatory terms in the Indian legislation perspective. Also, the uncertain royalty rates. What I will be suggesting is like that negotiating with the judiciary when there is a problem which is arising out of a FRAND license, which has multiple jurisdictions, which include the significant challenges in the Ericsson and Lava case. Also, there are still legal complexities which is more dependent on the market certainty. So I need to say that there is a need for a policy framework which might harmonize both FRAND and competition law perspective in India.
All right. You have also included this in your paper.
Yes, sir.
Give a thorough assessment of the competition laws, how the FRAND can be connected into the competition law, and included the comparative analysis from the published researches of the WIPO, WTO, and was as well as the FRAND committee report.
Yes, sir.
Okay, all right.
Thank you.
Now we'll be moving ahead with the next participant, Rahim Khan. Abdul Rahim Khan from Aligarh Muslim University. Are you present, Mr. Abdul?
Yes, sir. Hello, am I audible?
Yes, you are audible, but you are not visible.
Hello.
Yes, you are visible. You may present your presentation.
Yes, just a minute. It's processing. So it's showing processing. I will start when it will be done.
Mr. Khan, you can start your presentation. When it would be loaded, it would be automatically reflect in the screen. Yes, you can start.
Oh, okay, sir. So greetings everyone. Adab. I am Abdul Rahim Khan, and with my co-author Abdullah Azmi. Today we are going to present on the topic that regional FRAND licensing for South Asia, addressing the the standard essential patents, what it is, and the patent dependencies in the pharmaceuticals and green technologies. So let's have a brief. What is FRAND? FRAND means fair, reasonable, and non-discriminatory licensing framework, which often fails to account for South Asia's economic realities, diverting resources from indigenous innovation and perpetuating technological dependency. The recent COVID-19 pandemic exposed these vulnerabilities as patent and licensing cost-related complexities affected vaccine production and access. The high licensing costs are given from the company. For example, if I have the patent, if another person wants to use that patent, he should have my license. I should give him the right to use. This is licensing. For essential pharmaceuticals, limit access to life-saving treatments, while in green technology, we can say climatic technologies like the cloud seeding, for example, patent related fees increase the cost of renewable energy systems, hindering climate adaptations. So we can see that the leveraging the TRIPS flexibilities. There was a case very famous, next ever precedent. This case in India was also seen as a landmark judgment because in this case, the India's compulsory licensing of Bayer cancer drug in Nexavar in 2012 demonstrates that potential of alternative licensing mechanisms. This reduced the drug price by 97% from approx $5,500 to $175 per month, while requiring royalty payments to Bayer, meaning thereby if a person buys a medicine, some percent of that royalty or the profit will go to the Bayer company, Bayer Corp. This landmark decision utilized TRIPS flexibilities effectively. So 1 minute. Yeah. Just a minute. So you can see the methodology, mixed methods approach. We can approach it. Our study employs a mixed method approach, integrating legal analysis, economic modeling, and stakeholder consultations to develop the South Asian essential technology framework. Let me tell you that the person, why does he use a medicine? Why does he goes to a doctor? He goes to get a cure. But if this cure, if this disadvantage, if this helplessness is taken as an advantage by the pharma companies, this is not good for our society. For example, patents are very important, we can understand that, but there is something that if a pharma company compulsorily patents it but it does not gives the license, it has a monopoly over it. The Indian law, which the intellectual property and the competition law are, we can say, friends in disagreement. They all work in nexus. For example, intellectual property, the patent say gives a person monopoly. The competition law gives a person that everyone should be able to use that product. But if we finish intellectual property, then there will be no development of intellect. If we finish competition law, there will be no develop of, there will be so much monopoly. So there must be a balance. Why we can create this balance? By economic modeling and patent analysis. This examines the SEP costs and projects framework benefits using publicly available trade statistics and patent database information. And this can be like data triangulation and validation. This cross validates findings using WIPO, WIPO, patent scope, patent data, WIPO lex, legal information, and publicly available economic statistics. We can analyze the existing FRAND mechanisms by four global FRAND frameworks, Indian SEP jurisprudence, which we saw in the next ever case, and the economic impacts and the green technology challenges. In the SEP jurisprudence, we can see Article 31 of the TRIPS, which says about the compulsory licensing, and the Section 84 of the Patents Act, which says about the compulsory licensing also. I've mentioned it. It says that the non-working unaffordable prices of patented article, and the Article 31 says this, such as the grant of compulsory licenses due to the non-working, and it is given under Article 21 of our Constitution. It comes under the right to health. It is our fundamental right, which because medicine is not a privilege; it is a necessity. Our proposed South Asian Essential Technology Framework says the graduated FRAND pricing means that the tiered rates based on GDP per capita inspired by India's next ever case. The according to the census, the 50% of the world's population lives in these India, China, Bangladesh, Myanmar, in this great circle. So, but the population here is very poor. They cannot afford any kind of medicine, and so the medicine rates, the royalty rates of these pharma companies should be decided according to the GDP per capita of these countries. We can see by the patent pools, the aggregates SEPs in critical sectors, like for example, pharmaceuticals and green tech. These both sectors are very large sectors. Pharmaceutical is, we can say, the very large sector in the world, and green technology, which controls which I think so, it started after the 60s. The environmental approach towards the earth, the green technology, we have to save our earth. That type of ideology developed and more developed after the 90s to streamline licensing and reduce the burdens. We can have the technology transfer and capacity building. We can have bilateral agreements between the countries and training to enhance local innovation and reduce dependency. Local innovation, we can see, meaning thereby the standard generic medicines, which is very much used, and India is also said as the hub of generic medicine. We can by this we can reduce the dependency of the foreign western, more primarily pharma companies. We can implement these by having a 5-year term, like a 5-year feasibility pilot programs, then region wide scaling. Because in India we can see the diseases are very wide range. In the health sector, I'm very sorry to say, it's very bedridden. We cannot say it's very good. It's not in a very good condition. We have to develop, and this is not a good for a country that we have
We'll
so
try
much.
to conclude it in 1 minute.
Okay, sir. Of course, sir. So I was saying about the implementation strategies, the legal and regulatory reforms, capacity building, and risk mitigation. Our conclusion and recommendations would be like the adopt a 60-month implementation timeline, established a SARC trust fund for the specifically for pharma and green technologies, harmonize the legal frameworks. We should align patent laws with the TRIPS article of the Article 31 of the TRIPS, foster stakeholder consensus, position South Asia as a global model, and enhance the capacity building. Like, for example, train 100 patent examiners and judges over 36 months. We more specifically saying that we don't have in the judiciary the judges who are specializing in the pharma sector or the green technology sector. Thank you, sir. And in the concluding remark, my friend would like to say some couplets.
In the end, I would like to read some couplet from the Urdu.
Okay, so one question I'm having from my end: what structural and legal challenge would South Asian country face, like for creating the FRAND licensing framework for SAP in pharmaceutical and green technology? Since you guys has mentioned this in recommendation that the comparative based pricing should be provided. So, what according to you the comparative based pricing and the accessibility structure should look like?
The According to us, according to our research and search, we thought that we give a proposal that we can train and give scholarships to our scholars in this country and send them abroad, where the pharma companies, where the country is having a good pharma sector and very developed pharma sector, and we can send them there and they can train over there and can come back. This approach have been, for example, done by the China. They have in every sector they have sent their people, their citizens to another countries to get them trained to the modern world. For example, if we can send our the citizens of the India scholars to the European company, for the example Germany, USA. So these
You are having a network issue, team. We had lost the connectivity with you. Okay. So we'd be moving ahead with the next participants. Miss Aniruddha Roy. Aniruddha Roy, are you present?
Yes, sir. So I'll be sharing the screen in a moment.
You are not visible, Mr. Aniruddha.
Am I now?
Yes, you are visible. Yes, please present your screen.
1 minute, sir. It is processing. You can start the first part.
All right. Uh, Greetings to everyone present over here. I am Rajeshri Ghosh along with Anirudh Roy. Today we are going to present on the topic SEPs in perovskite solar cells for India's renewable energy leadership in the South Asian Ascendancy. Distinguished scholars and policymakers, thank you for joining us today to discuss a pivotal issue in India's renewable energy journey: the governance of standard essential patents or SEPs in perovskite solar cells or PSCs. SEPs, as we know, protect technologies that are necessary to implement an industry accepted standard, ensuring that products and services from different manufacturers are compatible and interoperable. While in perovskite solar cells or PSCs are a type of technology that uses a perovskite structured compound
as its active light absorbing layer to convert sunlight into electricity. As India strives to achieve 280 gigawatts of solar capacity by 2030 under the National Solar Mission, PSCs emerge as game changer. Their remarkable efficiency exceeding 25% and low cost production make them ideal for addressing South Asia's energy poverty. Nascent field will determine whether this technology will become a beacon of equitable progress or a privilege confined by patent monopolies. In India, we see 20% of rural Indian households lack reliable electricity. This is the field where they can emerge as an exclusive field. Firstly, moving forward with the research questions, let's consider how SAP architecture can strengthen India's solar leadership while ensuring affordability. PSCs, while their cost effective fabrication, are poised to transform energy access in resource constrained regions. However, the global patent landscape, dominated by firms like Oxford PV and China Solar, with over 1,500 PSCs patent filings by 2023, risks creating barrier to affordability. To counter this, we propose a tiered FRAND, fair, reasonable, and non discriminatory licensing model inspired by India's pharmaceutical licensing successes. As said and explained clearly before the presenter who presented before us. By adjusting royalties rates to economic capacity, this model prioritizes low income markets, ensuring PSCs reach rural India. Standardization, though the International Electrotechnical Commission's photovoltaic directives, further supports interoperability, fostering a competitive market that benefits manufacturers like Adani Solar and end users alike. Moving forward, India's legal framework, notably the Patents Act of 1970 and the Competition Act of 2002, offers robust tools to balance PSC innovation with energy equity. The Patents Act compulsorily licensing provisions, as seen in the landmark cases, can ensure affordable access to SEP protected technologies, addressing the needs of 300 million rural Indians without reliable power. Meanwhile, the Competition Commission of India can curb anti competitive practices such as excessive royalties, drawing on precedents from telecom SEP disputes. Unlike the EU's uniform patent system, which prioritizes enforcement, India's focus on public welfare provides a model for equitable technology diffusion tailored to South Asia's socio-economic realities. The next will be dealt with Mr. Anirudh Roy.
Thank you, Rajashri. Finally, patent consortia can mitigate global patent oligarchies and foster regional synergies. The concentrated PSC patent landscape threatens to exclude smaller South Asian innovators. A South Asian patent pool modeled on medicine's patent pool and coordinated by India through institutions like IIT Bombay and SARC could in future aggregate SEPs, reduce licensing costs, and promote technology transfer. By integrating global patents from firms like China Solar with local innovators, this consortium would empower manufacturers like Adani Solar, enhancing South Asia's innovation ecosystem and advancing energy parity. In conclusion, the governance of SEPs in PSCs is not just a legal issue, it's a strategic fulcrum for India's renewable energy leadership. By implementing tried FRAND licensing, leveraging India's legal apparatus, and foster patent consortia, we can ensure PSCs drive equitable progress. India has the opportunity to not only meet its 2030 goals, but also set aside as standard for green technology governance, transforming PSCs into an instrument of sustainable upliftment for South Asia and beyond. Thank you.
Okay, team, like how can India come up with the developed governance mechanism in standard essential patent for the solar cell, which can ensure both equitable access to renewable energy and fair return for the investor.
Sir, there are many legislations like the Patents Act, which already provides with tools such as compulsory licensing, as we can see in Section 84, which can be tailored for green technologies which are critical to public welfare. Further, India can introduce explicit statutory provisions on SEPs, defining their status and embedding FRAND obligations, like the ETSA rules in telecom. And also we can take examples how it is done in Oxford PV and China Solar, and domestic manufacturers can take an example from there.
Okay, and specifically you mentioned the compulsory licensing sections of the Patent Act, whether it would be applicable for the SEP. Yes, Rajeshri.
Yes, sir. So moving forward, sir, section 84 of the Patents Act permits compulsory licensing, and if there are reasonable requirements for that of the public and are not met, the invention is not available at really reasonable and affordable price. So we need to
So
look to that
first you have to
that part.
understand. First you have to understand the two segment, specifically the compulsory license segment and the FRAND licensing, like a fair, reasonable, and the equitable grounds, whatever has been developed by the FRAND compliance, are two different things. When we talk about the compulsory licensing is not only in patent. We can also see compulsory license segment in our copyright act, also like in very few extent in like trademark act. So compulsory license are basically provided for those when the benefit sharing objective of an IP is not workable. Let's say all the IPs are provided for the societal development, for the development of the society where the people can utilize out of it. Let's say a patent has been developed, but the purpose of the patent is not getting fulfilled. There are conditions for the compulsory licensing. First is it is not coming up to the purpose of the public utility. Second
Yes.
condition, it is not accessible to the public. And the third condition is the accessibility is hindering by the cost. So then only a compulsory licensing can be made. That's a complete different concept. But when you talk about the ACPs and the friend licensing, it's about the equitability and the market regulation for assessing specifically the price valuation, of all the licensing terms, to have the licensing regulation of their prices, specifically the royalties, in a regulated manner, so that the developers or the SAP holders doesn't arbitrarily charge the people. So that's the objective, and the two different objectives are for the different purpose. So like my suggestion for your paper comes within the scope of like assessing the objective of SAP along with the friend, and also how far it can go for the developing countries like India, like where many changes, so the rapid innovation changes are coming up. Because at the end we have to understand, India is growing up in a power hub where we see the Western countries are lagging behind the human capital. Right,
Yes.
currently in the India, uh, India is only the country which is contributing most of the human capital that is in intellectuality. India is contributing more than any of the other countries working in Western nations, or in the West. So that's how we have to assess it and thoroughly make the changes as per the suggestions. Understood?
Yes, sir. Thank you so much,
Oh,
sir.
Yes,
all
sir.
right.
Thank you.
Okay, host, we can move ahead with the next participant. Host, you are not audible. Okay, we'll be moving ahead with the next participant. Yes, Aviksha Das, are you present? Okay. The next participant is Saksham Singh Pamar. Mr. Saksham, are you present?
Yes, sir.
Okay. So you may present your presentation.
Thank you so much, sir. I hope I'm audible and visible as well.
Yes, you are audible and visible, but your presentation is not visible.
Yes, sir. Yes, sir. Just a second, sir. It's processing the PPT.
Yes, Saksham, you can start your presentation.
Yes, sir. A very warm good afternoon, sir. It is a true honor to present before you today to discuss a critical challenge at the nexus of intellectual property, technological innovation, and global justice, which is the dilemma of standard essential patents in the age of artificial intelligence. My research is driven by a fundamental question, which is, can a legal framework engineered for the static, tangible world of hardware, such as chips and radio models, possibly govern the dynamic, interactive, and data-driven nature of AI without stifling the very innovation it's meant to promote, particularly in the developing world, such as global south or etc. To appreciate the problem, we must first understand the old equilibrium. The SEP and FRAND system is in fact a masterpiece of legal engineering. For standards like 5G or Wi-Fi to work, everyone must use the same technology. Standard setting organizations mandate that patents essentially to these standards be licensed on fair, reasonable, and non-discriminatory terms. This delicate balance prevents two abuses. First, hold up, where a patent owner demands exorbitant fees after an industry is locked into the technology. And second, hold out, where manufacturers delay or refuse to pay for the technology
Mr.
they use.
Saksham, you can skip these definitions and role of SAPs. You can straightly go
Yes,
to
sir.
the
Yes, sir.
challenges. Yes.
Yes, sir. Yes, sir. I'm just explaining the what my paper is building. It will just take a second. But I would like to emphasize that the artificial intelligence shatters this decades-old compromise. The value of an AI system does not reside in a discrete piece of hardware. It lives in its algorithm and, more importantly, in the vast proprietary data sets which is used to train them. This creates a fundamental mismatch. The entire concept of a fixed one-time royalty for a static invention collapses when facing a model that learns and updates continuously. The question is, how do you determine what is essential to a standard when an AI function is a black box of patented algorithms, open source code, and protected data? This ambiguity fuels royalty stacking, a very dangerous scenario where the cumulative cost of countless patents makes innovations prohibitively expensive, especially for startups and firms in the global south or the developing economies. Globally, global jurisdictions are responding in divergent ways, such as the United States largely views FRAND through a contractual lens, focusing on promoting willing licensees only from injunctions. The European Union, led by the landmark ruling of Wavi versus ZTE, applies a competition law framework, establishing strict procedural steps to ensure good faith negotiations and prevent the abuse of market power. But some of the most innovative responses are emerging from the global south itself. Indian courts, for instance, have pioneered the use of conditional injunctions and escrow accounts. In the recent case of Dolby versus Lava, the court found Lava to be a holdout implementer. That means they were stopping the payments and means they or also delaying the payments. The court allowed them to continue selling products, but only if they deposited significant interim royalties into a court controlled account. This is a masterful legal innovation as it protects the patent holder's right to be paid while preventing them from using the threat of a shutdown to coercively extract unfair terms from local manufacturers. This set as a precedent. Yes, the risks posed by AI are even more profound. We are now facing novel antitrust nightmares such as algorithmic collusion, where self-learning pricing tools could tactically align on super competitive royalty rates, creating a digital cartel that is nearly impossible to detect or prove. The second is data monopolies, where a handful of tech giants control the unique data sets that are the lifeblood of AI, granting them an unaccessible market advantage that exists completely outside the purview of current FRAND rules. For developing economies, this power asymmetry is existential. Local innovators face a stark choice. Either accept the enormous terms set by distant data oligopolies or be permanently locked out of the next technological revolutions or so. So the question is, what is the path forward for it? We must boldly reimagine and adapt the FRAND framework within the artificial intelligence age. So obviously, this is not a small task, and my paper also tries to give a very surface level solution, such as the start from where we can start. The first is international action. Uh, Bodies like World Intellectual Property Organization and the World Trade Organization must take the lead to define, first of all, define what AI essentiality even means, and to explore groundbreaking concepts like, for example, data FRAND principles, which would ensure fair access to the critical data sets that power these standardized artificial intelligence. Second would be to flexible licensing models. We must move beyond one-time fees because we need dynamic models where royalties are based on usage, performance, or different metrics that reflect the true evolving value of the AI technology and application. And third, which is most important and also pointed out by the previous presenters, capacity building. We must invest in legal and technical expertise within the global south, which means judicial training, strong competition authorities, and to use resources which ensure that developing nations are not just rule takers but active participants in shaping these new governance landscapes. In conclusion, I would like to say what my paper is saying, that the rise of artificial intelligence does not make the FRAND system obsolete, which is being predicted by many people. On the contrary, it makes its core principles of fairness, reasonableness, and non-discrimination more vital even than before. The choice before us is not between protecting innovation and ensuring access. The great challenge of our generation, of our time, is to do both. By modernizing this framework, we can strive to ensure that the AI revolution becomes a tide that lifts all boats, driving inclusive and sustainable technological development for all humanity, not just for the powerful and privileged few countries. Thank you so much.
Okay, Mr. Shaksham, how can FRAND commitments be interpreted to address like the challenges in the AI generative and machine learning? Because those scatters into the domain of copyright.
Sir, when it comes to AI revolution and all, the patents are generally taken for the technological innovation which is happening, and that what the SEPs also tells us, that the technological innovations which happens, they have to go through the standard essential patents rules, and they have to make the rules as if
See, when like my question is, first try to understand. Are you talking about the generative AI and machine learning as a machine, or like the product of the generative AI or machine learning?
so the product. I'm talking about the product. For example, I'll give you an example. Like for
Okay,
example,
when you are talking about the product of the generative AI and machine learning, you have to first come and assess the two things. Specifically, that product is has to be a something which runs in functionality, because when you talk about the patent, it's about functionality. There is a
right.
functionality test. It have to be justified into the functionality test. But when it qualifies the functionality test, then you have to see whether it's a standard which is very essential, that will come under the SAP. If it is not standard which is essential, it will not fall under SAP. If it fall under the SAP, then only the FRAND is applicable.
So
Yes.
that is my first recommendation in my paper, that the WIPO organization and WTO organization needs to define this essential within the AI terms. That they need to they at this point they are defining essential terms with the static function which is already going on, the static trade which is going on. But what about when the AI starts evolving, and through time, when AI gets indulged with, for example, the microchips which are made like for example, in the Russia-Ukraine war, the AI chips were used in the tanks and everything. Who looks at the FRAND rules when it comes to these type of products? So this is the major challenge which will be happening in the future, and I think that what my paper recommends, that like as you are also saying, that the international organization should firstly define the functionality, or based on the functionality they should define the essentiality of these AI tools. That's what I'm saying.
Okay, specifically, like my assessment on your papers goes upon the like a doubt. You have to first take these two like suggestions. When we work upon the generative AI and machine learning, so generally it falls under the domain completely. The machine learning falls under the domain of copyright. How it falls under the literary work, because all the codes and all these like the technological aspects of the generative AI is itself a copyrighted subject matter. So when you talk about the devices of that subject matter, then it will fall under the patent and innovation segment. So now, like your assessment analysis of the paper should be more connected, like how you will be first you would be distinguishing it, how generative AI and machine learning is not a copyright subject matter for your paper's perspective, and then you would be taking up the functionality aspect of that particular generative AI and machine learning, and you will be utilizing it, assessing it with the SCP segment, and thoroughly the paper should analyze it and channelize it, and then your friend commitments and the inter representability interoperability would be assessed. So that's how the paper channelization should be done. Understood?
I completely understand the point, sir. I think my paper is already setting in the means, I will make the necessary recommend what to suggest changes. I think as of now, my paper is talking about only the SDGs, and only if food means in the domain of patent innovations, because I completely get the question about the copyright, and that is a very basic question which comes forward, that who has the copyright on the AI works. That is a very basic
See,
question.
if you are breaking the notion, see, if you are breaking the notion of the society is generative AI and machine learning falls under a domain of copyright. That's a concrete and set standard. If you are breaking a notion, then you have to justify yourself that why it's not copyright, why the patent will come into existence? So that's what I am that's the loophole in your paper, and it had to be
Got it.
corrected. I
Got it,
believe you
sir.
got my
I got it. Yes,
yes.
sir. Yes, I got it.
All right.
Yes. Sir, is there any other feedback on my paper?
No, that's only the point which I wanted to tell you. You have to incorporate these changes, then your paper would be okay.
Thank you so much, sir. Thank you so much.
Okay. Yes, host, it's over to you. So the next participant is Priyanshu Kumar from Amity University, Jharkhand. Yes, Priyanshu, you are audible and visible. You can share your presentation.
Yes, sir. Just a second. So, is my screen is visible now?
Yes,
Hello.
it's visible.
Okay. So, good afternoon. My name is Pinanshu Kumar. The topic that I have chosen for today's presentation is From Patent to Pixels, a study of intellectual property rights through digitalization. So, in this presentation, I will walk through how digitalization has transformed intellectual property rights, what challenges have emerged, how the legal system is trying to keep pace, and finally, what are the future might look like. By the end, I will hope to give a clear idea of it. So, firstly, with the introduction part, IP is generally the really the backbone of innovation and creativity. Without protection, no one would want to invest their time and money into new ideas. Traditionally, IP protects for slow, bureaucratic, and paper heavy, but the digital revolution has changed all that. Today, IP can be filed online, checked with AI tools, and even monitored using blockchain technology. This has made it easier for inventors and creators to protect their work. But here the flip side, with the technology making sharing and copy so easy, piracy and counterfeiting have increased dramatically. For example, movies got leaked online with hours of release and fake branded products circulate worldwide through e-commerce sites. Through the challenges is clear, while digitalization has made IP protection faster and more accessible, it has also multiplied the risks. The aim of my presentation to explore this transformation, how digitalization is reshaping IP laws, what new challenges it brings, and how the law can adapt for the future. Emerging technologies reshaping in IP filing. Technology is not only creating new products, it also reshaping the values, concepts of IP laws. Firstly, take patent for example. Earlier, patents were about machines, engines, or physical devices, but today we have patent for algorithms, AI models, and even biotech inventions. In India alone, 2000 between 2010 and 2015, AI-related patent grew 7 times, crossing 86,000 filing. That shows how powerful digital technology has become in shaping innovations. Trademarks have also become critical. With the rise of e commerce and social media, a brand online identity is as valuable as its physical one. Imagine someone is misusing Amazon or Flipkart name in the digital space. It could confuse millions of customers. Copyrights are perhaps the trickiest. AI can also write poetry, compose music, or even paint. But who is the real author? The AI, the programmer, or no one? This is a serious question that legal systems around the world are debating. So emerging technologies are not only changing industry but also forcing lawmakers and businesses to rethink how IP should work. Legal framework in digital era. When it comes to law, the reality is that traditional framework are struggling to keep up with digital changes. Let's take copyright first. Piracy, streaming theft, and digital copying are everywhere. Platforms like Netflix or Spotify spend billions fighting these issues, but piracy is only a click away. In patent, we have the debate around AI inventionship. Stephen Thaler case raised the question of whether a machine can be named as inventor or not. Court in different countries said no, but the debate is far from over. Trademarks are also vulnerable. For example, cyber squatting, where people buy domains names similar to famous brands, create confusion and financial losses. In the metaverse, companies are already facing misuse of brand logos in virtual spaces. On the global level, treaties like TRIPS and WIPRO copyright treaty some guidance, but the problem is that these frameworks were designed before the digital boom. As a result, enforcement is often inconsistent or too weak for today's reality. Practical challenges of emerging tech. AI is the biggest one. If a machine creates something new, can we call it an inventor? Imagine if an AI developed a life saving drug. Should the patent go to the AI, the programmer, or the company funding it? This is a tough question. With the Internet of Things or LOT, billions of devices are collecting data every day. Your smartwatch records your heartbeat, your phone tracks your location, and even your fridge might be smart enough to know what you eat. But who owns this data? That's still unclear. Blockchain and NFTs have made ownership is owning a artwork through a NFT does not always mean you have full right to use or reproduce it. Deepfakes are another big threat. We have all seen videos where celebrities or politicians appear to say things that they never actually said. This violates privacy, harm reputations, and create legal confusion about copyrights. Some landmark cases highlights these issues. First one is Stephen Thaler versus Cropter of Patents. The court ruled that AI cannot be named as an inventor. In another case, Tata Sons versus Greenpeace, the court balanced trademark rights with the right to
Mr.
free
Priyanshu,
speech.
you can move to the solutions and conclusion part.
Okay, so just a minute. I will explain a little bit about market perspective and future of IP. Okay. From a market perspective, intellectual property is not just legal protection, it is a valuable business asset. Companies with a strong patent portfolios can negotiate better deals, license their technology, and attract inventors. In fact, some companies use patent as bargaining chips in international business negotiation. AI powered IP tools are also making process faster. They can help with prior art searches, patent drafting, and even detecting infringements. Looking ahead, we can expect rapid growth in patent in areas like biotechnology, renewable energy, AI, and quantum computing. Globalization will also demand harmonized IP laws. Without global cooperation, enforcing IP across border will remain difficult. So, what are the challenges that may face? First one is piracy and copyright infringement. Rising online piracy. As India previously in 2023, the rate was around 62%. And the second one is that is challenges is trademark violation in the digital space. Counterfeit goods sold online under famous brand names. So now my suggestion and recommendation in my paper is first one, stronger enforcement technologies. India should invest more in digital tools like AI and blockchain based tracking for IP enforcing. Second one, IP and policy reform. Update laws to handle AI generated works, blockchains, NFT, and emerging tech. Make IP legislation more eligible, responsiveness, and proactive. Global cooperation. Push for a unified global IP framework beyond TRIPS to reduce inconsistencies in enforcement across countries. Fourth one, modernization in IP filing. Simplify, digitalize, and speed up filing process worldwide. Use AI tools for patent search, drafting, and trademark automation. Education and awareness is the last and most important part. Trade innovators, startups, and students to understand and protect their IP rights. Thank you so much. Hello.
Yes, specifically talking about the digital transformation, what you suggested in the last portion.
Yes, sir.
Yeah, so I have one question for you. How has the digitization transformed the protection, enforcement, and commercialization of IP? Like when it comes under the generative work, NFTs, and the digital patent databases?
So, सबसे so first of all, तो 1 minute. Battery is low. So, what you have asked, please repeat the question again.
How the digital transformation has completely changed the dynamics of the IP, like commercialization and the legal emergence within the area such as NFTs, generative AI work, and the digital patent database. That's my question is.
So, digital technology has transformed IP from a static rights into dynamic global commercial asset. Firstly, earlier publishing a book, producing a movie, or selling art requiring a big infrastructure. Now, anyone can create and distribute content instead ebooks, music streaming, or NFT and YouTube. So now, global mark. So first of all, copyright in the digital environment. Piracy becomes rampant. Laws introduce
See,
Wipro.
like there are two suggestions you should incorporate in your paper. Presently, your particular the research work where you had analyzed intellectual property and the digitization, you have to
जी sir.
first assess the work as per the digital patent data sets, and also like you have to incorporate the other IPs of the generative work. So you can incorporate the NFTs and the emerging technologies, and the new legal challenges, assesses what are the new legal challenges when it comes to digitization. Now for the present time I can give you two legal challenges where you can work upon. Specifically, the major legal challenge when it faced in the digitization is the credibility of the IP. Like let's say new technologies are being deriving now. If videos can be generated by the generated AIs, how to trust
Yes.
those kind of credible content? And this is the first challenge, and the second challenge imposed by its are the generative work that can be any audio, video, in any kind of thing. The identity personification, identity crisis is one of the major challenge which you can assess upon this particular IP. As here, the right to privacy also would be like the one of the major question of work, and the commercial viability of the IP along with the infringing of the personal rights should also work upon. Understood?
Okay, sir. Okay, sir. Thank you so much, sir.
All right. Yeah.
So, can we proceed with the next participant?
Yes.
So, I would like to invite the last participant of the conference, Harshimran Kaur Batra, from independent researcher as Dr. Bhimrao Ambedkar Law University, Nagpur, to present.
Good afternoon, everyone. Give me a second.
Miss Simran, please present your screen.
Yes, sir. Is it visible?
No, it's not visible yet, Simran.
Okay.
Yeah, now it's visible.
So my topic is reassessing patent pools, antitrust risk in platform-based licensing of SEP. Okay. My research question is based on how do patent pools such as Avinci impact antitrust compliance and the enforcement of FRAND obligation across United States, European Union and China. And how can these platform-based SEP pools create risk of collective dominance, disproportionate royalties and market foreclosure. So we have seen that we are moving towards Industry 4.0. It is an era of digitalization. And as we are moving towards this era, we are also using 4G, 5G in everything that we have, including smart cars, smart TVs, smartphones, etc. And all of these these IoTs need standard essential patents. So these are specific inventions that require patents from these major holders. Now, what does patent pools do? These patent pools collect SEPs from different major holders and compile them and give one license to the end manufacturer. Now, my main focus is on the Avanci model. So Avanci, it's a platform, it's a patent pool platform which provides joint license for essential technologies. Its main focus is providing 4G and 5G vehicle platform. There are more than 130 plus licensors on Avanci, including major licensors like Acer, Nokia, Lenovo, Philips, and a lot of licensees, major licensee groups like Bentley. Here, the main thing that we have to understand is Avanci only licenses towards the end manufacturers, the OEMs, and not to upstream manufacturers. So it collects 4G, 5G technology from all these licensors and give these to the major licensee groups, major car manufacturers. Now there are three antitrust risks in Avanci model. First is collective dominance. Since I've already told how 130 plus SEP holders are part of this Avanci model, including Nokia, Ericsson, Qualcomm, these are big players. Again, a aggregation of these big players also means that there is a threat of collective dominance. They can easily distort the market, and there have been multiple instances where some of these players were alleged to have distorted or used collective dominance or have I'm sorry, I'm forgetting. I'm going to move on. Second point is disproportionate royalties. So Avanci uses a fixed fee model. That means every particular vehicle royalty is fixed. If a particular vehicle wants to incorporate 4G model, then they have to pay $20 per vehicle. If they want to use 5G model, they have to do $32 per vehicle. Now this means that a major car manufacturer is paying the same price as a startup company or startup car manufacturer. The third point is foreclosure of upstream manufacturers. So since Avanci does not license to upstream manufacturers, it means there is stagnation of innovation because there is only access for the bigger manufacturers, and therefore innovation can only be done by these manufacturers. Next, so with exclusion of upstream manufacturers, there is innovation stagnation. And with innovation stagnation means there will be no competition in the market. No competition would mean there will be a constrained market for licensee. That means no alternative for the licensee, and therefore these licensee would have to negotiate with the same major SEP holders to get license. So again, because they are negotiating with the same major SEP holders, there is market dominance, and again there is exclusion of upstream manufacturer. I've the global enforcement approaches. So here I have talked about how USA, European Union and China enforce SEP pool guidelines. So through comparative analysis, I have found that USA has patent and antitrust law which is more pro-competitive. That is, they are more complementary towards each other, and they find that these patent pools leads to more competitive and more market innovation, while in European Union, so they have more balanced approach, as in their treaty on article 101 of treaty on the functioning of the European Union, where they prohibit price fixing, that is fixing of the prices at a particular point, market restriction and unfair licensing. And China is more interventionist. So they have, in the Qualcomm investigation, they have found that Qualcomm was abusing dominant market position, and they levied a fine of around $935 million. And I have also seen that in certain cases like Microsoft versus Motorola, in Huawei versus ZTE, FRAND commitments were upheld. Let me talk about FRAND commitments. So these are standards which are set by a standard setting organization. These are voluntary agreements containing certain technical
Miss
specifications.
Simran, you can move to the recommendations and suggestions.
Okay. Um, Let me talk about the cases just. So in Microsoft versus Motorola, we have seen the court supported RAND terms. In Huawei versus ZTE, again, we see that the Justice Court also supported FRAND terms and talked about if they want injunctive relief against a particular infringer, then they have to first notify the infringer of the patent and submit a FRAND licensing offer. And once the infringer denies to negotiate on good terms, then only they can seek an injunctive relief in the court. Now, in Qualcomm investigation, again, Qualcomm was fined because they were distorting or putting high royalty fees and creating a bundle. Creating a bundle in the sense that they were tying up multiple patents, which were, some of those were expired and some of those were totally not necessary. So again, what are the structural reforms they are needed? First, transparency in royalty allocation. So how these royalties are calculated, how the patent are used in the end product, and a lot of use in the economic sense can also be integrated. Second, flexible royalty model. This means that, as I said, a lot of even OEMs have different needs. Some OEMs, such as some startup companies in car, can are not able to afford the same rate as high OEM manufacturers like Bentley, Rolls Royce. Then the third is non-discriminatory access across supply chain. So there should be an access towards the upstream manufacturer to increase innovation and increase market competition, etc. Preventing collusion with bilateral agreement. So bilateral agreement is when it is a one-on-one agreement between two SEP holders. So that will reduce collusion between major SEP holders and not distort the market. And lastly is international harmonization. So there's a need for a more harmonized policy, because as we've seen, internet connectivity, or Avanji has the market base all over the world. So we need a more harmonized policies. Yes, thank you.
Okay, Miss Simran, now tell me, how can a regulator distinguish between a pro-competitive and anti-competitive market foreclosure?
Pro-competitive and anti-competitive market foreclosure.
Yes.
There is a difference between, as if I'm just going to talk about the Avanci model itself, there's a difference between hampering innovation and pro-competitive would be that it would need more competition, more development, more innovation in the market, which is the main goal for patent and SEPs. But in these models, we have seen it is in turn creating a monopoly, creating a dominance, and creating a problem or stagnating innovation. So that will be the difference between the two. When a particular model starts hampering the innovation, starts hampering the economics, then there should be a policy change.
All
Well,
right.
it is very hard to distinguish between the two, but as I've said, there were multiple times that even US Department of Justice and FTC have said that such collusion can lead to hampering market economics, but yet we have seen in this case that Avanchi is allowed to use a one rate, a flat per
See,
vehicle royalty rate.
like when we talk about the royalty rates and the antitrust risk associated with the platform-based patent pool licensing, there is always a distinction between a pro-competitive collaboration assessment and the anti-competitive market foreclosure. So there are
Yes, sir.
various reports on the competition law. Even in India, like there are reports on the patent pools. If you researched well, you will get it. If even the CCI Competition Commission of India has published 2 to 3 reports upon the IP, and in that IP, the patent pool is one of such. So, like in all those, there are like 4 distinction which has been derived by the regulators. They distinguishes it on the basis of the market effect. Like if it is pro competitive, how much market is getting pro competitive. If it is like anti competitive, what is the effect of the price in the empiric and like competition and the anti competitiveness. So that's how the market assessment completely runs on the cost and profit. So what is the cost of development of that IP, specifically talking about the patent, and what is the profit the innovators are getting? If the innovators is getting a profit, like let's say, which is not even imaginable, or the not even like the innovator thought to get a profit of such kind of percentage, let's say 20%, but the innovator is getting an unpredictable profit of 1000 percentage spike, then definitely there is something which is happening beyond competition, that can be termed as a monopoly or anti-competitive practices. Again, if the innovator is getting the competitive price that's into market standard, then we can say
Yes,
that's
sir.
that's going on pro competitiveness. So these things has to be assessed well in your paper. Try to incorporate this kind of things.
Sir, I would like to add on to that that as I've said, in Avanchi model, they only license to the bigger manufacturers, OEMs, and they do not license to the upstream manufacturer, that is, let's say, the chip makers. As you have said, one of the reason why they don't license to the chip makers is because they will get a much less license fee. For example, a chip will be sold for $20. So for that, 5 to 10% would be $1 or $2 around. And the main reason why they license towards bigger manufacturer is because these are car manufacturers who will be sold for up to, let's say, $30,000 or more, and therefore a 10% of that would be around $300 or more. So again, this is one of the reason why they are not licensing towards these smaller upstream manufacturers. So this can be again a point that innovation is hampering. And if they are not licensing based on the royalty fees or how much they will be getting as profits, then this is a form of market distortion. Y- there cannot be a reason, there cannot be a reason for more competition, and you cannot say that we cannot license to upstream manufacturers because there is more profit towards the end
All
manufacturers.
right. All right,
Yes, sir.
Miss
So this
Simran,
is
try to
happening, but
incorporate. Yes, try to
yes, sir.
incorporate these
Thank you, sir.
suggestions. Yeah. All right.
So, can we proceed with the concluding session of this conference?
Yes, Sanskriti, we can proceed.
Okay, sir. So, as we come to the close of the International Conference on SAP and Patent Innovation 2025, it is my privilege on behalf of the organizer to extend a heartfelt gratitude. Good afternoon, everyone. And first and foremost, I express our deepest appreciation to Mr. Dipendu Das, Director of CDIPR, Naovina Development of Intellectual Property and Research Foundation, for his guidance, vision, and inspiring presence throughout this conference. I would also like to thank to all the participants for their active engagement has made the discussion vibrant and meaningful. Last but not least, sincere thanks to the organizing team for their dedication and hard work in ensuring the success of this conference. With that, we conclude today's proceedings. Thank you all once again for being with us, and we look forward to meeting you in future summits and collaborations. Have a wonderful evening. Thank you.
Thank you, all of you, all the participants, all the stakeholders involved. And we believe that we are contributing a bit step by step towards a conclusive society, having an understanding and awareness of the IP. And we'll be working in the awareness of each and every IPs throughout this summit. We are presently conducting these sessions uh, on the various programs upon like the South Asian Global IP Summit, and we will be working throughout our various programs coming months. I like dedicate my vote of thanks to all the contributory members and also the participants and the audience involved, and also our collaborative partners, Open Innovation Network and GIPC, for collaborating with the international conference on SEPs and patent innovation with us. So thank you. Stay in touch with all the programs associated, and definitely with the idea to come up with the inclusive SCP and the patent innovation models in colline with the FRAND licensing. We are concluding up this session. Thank you so much.